We're going to get started this morning. You all find a seat. Appreciate you all turning out today. We'll get going here. Just open us with a word of prayer this morning. Lord, thank you so much for the opportunity to be here today, and thank you for the people that you've brought into this room and the intellect that's represented here. And Lord, we know that there's a solution for most of the problems that we'll probably address in this conference and these committee meetings. And so we look to you for wisdom and guidance as we go through this day. We just ask your blessing upon everybody here in terms of the families that are represented here and the individuals who serve. Thank you for our armed forces and those people who first respond who are here today. And we just ask your blessing upon them as they serve this state and their cities. Thank you, Lord, for the opportunities of the day now in Jesus' name. Amen. Okay, well, I think it would be in order to thank you for all coming today to the first meeting of the Title 40 Study Committee. I thought it would be a good thing just to introduce ourselves for a few minutes and let you know who you got in front of us if you don't already know. I'll just start. I don't want Jay to take up 5 or 10 minutes introducing himself, so I'll just introduce him myself. I got a lawyer bias. That's true. That's Jay Powell over there, Chairman Jay Powell. He's chairman, one of the vice chairman of the Budget Committee. Long experienced guy in the governmental society, being a mayor, and comes from that kind of background. So it's good to have you, Jay. Thank you for serving. To my right is, as obviously many of you in the audience already know from seeing his face on many glorious days down the basement of the Capitol, Chairman Rich Golick of the Judiciary Non-Civil Organization. I always wondered when I went in front of that committee why they called it non-civil. And, I think I know by the questions that they asked, it's probably the Anyway, thank you for serving, Rich, and Rich will co-chair this organization with me. To my left is Alan Powell. Alan serves as the Vice Chairman of the Motor Vehicles Committee and is just a bulwark of knowledge on several different fronts, having been with us here in the legislature for several years. And then finally, Katie Dempsey is with us, and Katie serves also, recently promoted to the chair and the vice chair position in the Budget Committee, and we appreciate you serving with us, Katie, and thank you for being here. We have a couple other people. Is she here? Oh, there she is. I didn't see you come in, Nikki. Sorry about that. And we have Nikki Randall. Nikki, thank you for coming up today and serving with us today. We appreciate your help. I've known Nikki for a long time as a sixth floor CLOB compatriot. So, Nikki, welcome. Moving down the row here, our legislative council are here to assist. Jill Travis and Terry Long, thank you for coming. And then Craig Foster and Brandy Bazemore are both from the Member Services Organization, and they can help you with anything that we can't help you with. And it's probably their industry that put all this together today, and we thank them for that. We have an agenda that you've been made privy to. You're asked if you wanted to speak to get in touch with Craig or Brandy. So for the committee members, there is an agenda in your package, and we'll be following that for the balance of the time we spend together. Just a couple of opening comments on this. The reason that the Title 40 Study Committee exists is primarily, in my mind, for three reasons. First of all, the Criminal Justice Reform Council took some measures to ensure that the issue of decriminalizing traffic offenses was kind of on the horizon. And so a lot of people in a lot of areas, a number of the judges and the associations have worked through this, and are starting to come to a suggested policy change on this, and so we're anxious to hear from them. But that's one of the reasons that, and obviously the governor is very, very interested in this, as he's expressed to both Chairman Golick and myself. The second thing is that there are multiple areas of concern with the structure and viability of the dry red schools and some of the organizations that surround them, in terms of how that's all been put together as kind of a state-based requirement that puts these good people into business, and we want to address that. And also, we talked about the need to review and adjust the code sections and kind of reflect a more coordinated presentation of the law. I know several of you in the legal society out there have traipsed around Title 40, maybe used it as a bookend someplace, but you know, that's a pretty heavy volume of code, which has been maintained well, but at the same time, substantively, it's good, but it has a lot of opportunities for difficulty in coordination. Today's kind of an informational meeting. We wanted to provide the committee an opportunity to focus on the issues that you wanted to bring forward, kind of your meeting from that standpoint to set the tone for what the committee will do over the rest of the time that it meets. And we will take the opportunity to discuss these issues that are brought up at the end of the meeting today, and look at methods to kind of prioritize how we spend our time. The output of the meeting is obviously a set of recommendations. Is there any study committee that we come together on and make as a presentment to the House of Representatives? They eventuate, in many cases, some or in all, in parts, as legislation. And my personal objective, and I hope the objective of everybody in here, is really to enhance the safety of our drivers and our vehicles that are on the road, and frankly to ensure a system that's in place for protecting the privilege of driving and to work efficiently and effectively. And that's a challenge that is, I think, difficult to maintain, as we've observed over the years. So with that, anything from the committee in terms of the good of the committee that you'd like to say with regard to committee objectives or anything, or are we ready to start with the first agenda item? Seeing none, why don't we have those people who are going to represent the courts and the prosecuting attorneys council come on up to the microphone. I've got 6 of you listed here, so I'm not sure how many are actually going to come up. I think we've put some seats up there. You're going to have to pass the microphone around, and you good people can select who will speak for you and the order in which they will speak. By the way, for committee members, there are copies of the presentations we've asked them to make that are found in the front of the folders that you've got, so you can consider them as we go ahead. So why don't we do this? Why don't you guys identify yourselves? Because I'll trip through your names here in terms of, but we could probably say judge in most cases. So, Judge. Chase. Okay.
I'm David Darden, Judge Darden from the State Court of Cobb County, and I'm president of the State Court Council.
I'm Chuck Spahas, and I'm here in capacity as the Executive Director of the Prosecuting Attorneys Council.
I'm Stephanie Woodard. I'm Solicitor General in Hall County and President of the Solicitor General's Association.
Good morning. I'm Jim Anderson. I'm a municipal court judge in Sandy Springs and President-elect of the Council of Municipal Court Judges.
Okay, thank you all for coming this morning. Okay, who would like to start off?
If I may, Mr. Chairman, I'll get started. What we've discussed is I'm going to lay out how we got to where we're at and some things that have transpired since last year. Last year I served in the capacity that Ms. Woodard's now serving in as the representative on behalf of the Solicitor General's Association. I come from about 10 years of prosecuting in the state court prior to coming on board with the Prosecuting Attorneys Council. So, as you said, I've spent an awful lot of time in the 40 Code. One of the things that came out of the Special Counsel on Criminal Justice Reform last year was a provision that suggested changing minor traffic offenses from misdemeanors to violations, or creating a new class of violations that are non-criminal for those minor violations. So that created the conversation and discussion around the concept of decriminalization of a traffic code. What I want to do is kind of lay out a few hurdles that we have and kind of some reasons that things happened the way they did last year. When that concept was thrown in with, as you all know, the many other technical and complex issues surrounding criminal justice reform, there was not a lot of time to delve into that concept. And one of the concerns that the prosecutors had was the concept of decriminalization was, though it's been discussed in the past, it had not been adequately explored at that time, and that there was some grave concern that we would have significant unintended consequences of just simply making it civil. So what I'm going to do is, if I can, and that is why we found ourselves in a posture last year of saying, wait a minute, slow down. We support the concept of changing and modernizing our approach to traffic violations, but just a simple statement of making it civil and getting it out of criminal court creates an awful lot of issues. And what I want to do is briefly hit on those issues right quick and use those as kind of an explanation of why we couldn't support the concept last year, but let me make clear the prosecutors are here supporting the concept and the approach and the mission that this commission has, and that is to come up with a more modern and better approach to the way we deal with traffic violations. A couple of problems with the concept of decriminalization are making these offenses civil in nature. One of the primary concepts and concerns that we have is the law enforcement in this state have the authority oftentimes to stop vehicles because of the concept that these are criminal in nature. We've got several appellate court opinions about vehicle search and seizure laws that have turned on the fact that in Georgia and in most states all traffic offenses are criminal, therefore an arrest can be made, therefore a search could be conducted. So we have some serious concern about making that civil and undermining a bedrock principle of the search and seizure concepts in this state, and on some important appellate decisions that are relied on every day. Another issue that surrounds that concept with law enforcement is that, though it's not common, the availability of police officers to transport or have post a bond a traffic violator for various reasons, including concern over the real identity of the violator, concern about whether or not the offender would return to court later for various reasons. All of that authority would go away if those were civil infractions. Another concept that we would have to take into account if we were to go to civil in nature is that without some further action of the legislature, our municipal courts in particularly, and our state courts to a certain extent, would lose jurisdiction over the civil. They don't have civil authority over a simple civil concept. I'll give you an example of that. The DAs and the solicitors of this state only have authority where we've specifically been granted it. We've got several statutes out there now that have been put in place that are in the traffic code that were made civil penalties only, that we don't have the authority to prosecute. And I use for a specific example one that we had the legislature revisit last year in Senate Bill 352. That was the enforcement of the school bus camera laws. That law got passed 3 years ago, but there was no authority for the Solicitor General or a municipal prosecutor to bring that because it was civil only. We had to specifically go into the duties and authorities of the prosecutors last year to give us authority to do something with those traffic cameras. So after 3 years, there's 3 counties, I think, that this year haven't been able to actually put those in play and are now enforcing that statute. But we had to go back and revisit it to give us authority to do it. So that's an example of what our problem is with our very narrowly defined duties and authorities. Another issue that would be of concept if we make this civil in nature is, where does the Civil Practice Act fall in that? Currently, the prosecutors only have to deal with that in the forfeiture arena. We would have to figure out exactly how to deal with that. Does discovery in the civil arena now apply to these? Some basic concepts of continuances and how they're given and got. Anyway, that's another concept of dealing with the Civil Procedure Act. Another concept that you're going to hear from the judges is that we have a difficult time now, and that they are criminal, enforcing and getting people to court. And they now have remedies like bench warrants and failure to appear notices that suspend driver's license for failure to appear for these criminal cases, and that going to a civil penalty only makes that worse. It's one less priority people would have to deal with, and we have some genuine concern about the ability to enforce any kind of civil order or judgment that would be gained in these cases. I also point out that decriminalization would take these offenses outside the realm of the add-ons. And when I mean add-ons, I talk about the things throughout this state that are attached to criminal fines that fund all kinds of things, particularly state and, quite frankly, locally, that stream of income would be dramatically affected by the concept of decriminalization. So I lay all that out as just kind of the issues that we raised or saw last year at the simple concept of decriminalization. And as I'm going to turn this over to the rest of this panel, I do want to say that we've spent most of the summer meeting in various shapes, forms, and fashions to try to come up with a consensus of how to deal with this. And I think, quite frankly, you're going to hear that we have some suggestions that are coming from everybody that's been involved in that conversation collectively. But one of the primary things that did come out of that we all agree on is decriminalization doesn't work. There's not a state that has successfully done that, and we don't think Georgia could be on the forefront to do it without dealing with an awful lot of issues that I don't think anybody intends us to do. So if you start out with the concept that decriminalization is not a direction that we would suggest that this panel go with, we have another interesting dynamic in Georgia that needs to be considered. The standard U.S. Supreme Court, the standard that's been established as far as a jury trial or a right to jury trial, has been petty offenses for less than 6 months. You don't have a U.S. constitutional right to a jury trial. That's a basic bedrock constitutional concept that goes back a long time. The problem is Georgia, and Georgia's not in the minority by this. There's many states that have this provision in the Constitution. We have a specific provision in our Constitution that says, in criminal cases, the defendant shall have a public and speedy trial by an impartial jury. So if we get to the concept we can't decriminalize, then we can't get around this Georgia constitutional provision. And I think another concept that came consistently out of all this is nobody feels that going into the Constitution, which obviously requires a constitutional amendment to remove that requirement, is not a practical approach to this either. So those are two concepts that we came to collectively that we want to bring in front of this panel, and then I want to turn it over to specifically Solicitor General from Hall County, Ms. Woodard, and then the judges that are going to speak collectively from what we think we've accomplished. So thank you.
Thank you, Chuck. Why don't we just, everybody agree we can hold questions until the panel finishes up with their testimony and then go from there.
Good morning,
Thank
Chairman.
you. Thank you. Appreciate it, Judge.
Committee members, thank you for letting me speak. I'm a little uncomfortable going before the judges, so let me hurry. What I want you to hear overwhelmingly from me is, and from the Solicitor General's Association, is that we are very interested in cooperating in the spirit of the pursuit that we are here for. I wanted to make sure that the committee members were aware that there is not an opposition from the Solicitors Association and the people that live daily in Title 40. There is a grave concern, predominantly because of the criminal investigations that flow from those traffic stops. And I'm lucky in that I've worked in many jurisdictions in this state, from inside the Beltway and all of the metro counties in traffic enforcement, as well as from Carroll County to now Hall County. And I'm very sensitive to, that is one of the most dangerous situations that law enforcement officers face daily. I worked in Carroll County when Robbie Bishop, one of our state patrol officers, had the back of his head blown off during a normal traffic stop. We get a tremendous amount of weapons, drugs, and warrant situations that are faced every day in what the average citizen considers a nuisance or a daily, almost cost of doing business speeding. the folks that law enforcement officers encounter on the road vary from the worst of the criminal aspect to people just in the ordinary course of their business. And the flow of that investigation in that traffic stop, we must be mindful in crafting any changes to Title 40 in light of all of those considerations. We are excitedly anticipating some wonderful things that can happen in Title 40 where there are inconsistencies even among the way the driving offenses are treated. A second and 5 driving unsuspended is high and aggravated. A second and 5 DUI is not. And those are some places where they need to simply be adjusted and treated much more consistently, or specifically enumerated what the differences are. I think most people would argue that a second and 5 driving under the influence is substantially more potentially injurious than even a driving on suspended. So we're excited about the possibilities. We have been engaging in this discussion since our current governor was campaigning, because we were aware that this was something that was on the horizon. Under Mr. Spahas's leadership as president at that time, we've looked at many different jurisdictions, learned from the reality television that is their court, and what to do and what not to do, and just want this committee to know we're excited to be part of the conversation. We want to be part of the change. And we appreciate this body's efforts to go forward. Thank you.
Thank you, Ms. Wood. We appreciate you coming up today and providing that testimony. I'm sure there'll be some questions about some of the things you have thought about. We're going to hold questions until the end here, and you're going to go next here, and that's
yes, sir.
Another
Chase starts
Chase.
with probate court.
Chase. Yes.
Mr. Chairman, members of the committee, on behalf of the Council of Probate Court Judges, I would like to thank you for the opportunity to address you today with regards to the issues that pertain to Title 40, the courts, and most important, the constituents that each of us serve. There is no doubt that reform is coming to the criminal justice system on all levels. The need for change is usually predicated by an actual event or occurrence which demands our immediate attention. However, our Council reviews the proposed reforms of the criminal justice system, particularly those in Title 40, as a chance to proactively approach change in a simplistic, practical manner that better ensures justice for our citizens. Our Council firmly believes it is the intent of the state constitution for the legislative branch of government to create the laws of this state, and the same foundation is laid for the judiciary to interpret and rule on these same laws. As the General Assembly contemplates reforms to Title 40, we feel we have a duty to our constituents and to you, our legislators, to highlight items that we feel the General Assembly needs to be cognitive of as the process moves forward. As I'm sure you're all aware, probate courts have original and exclusive jurisdiction over traffic cases in which there is not a state court. In fact, there are currently 83 probate courts in Georgia who have jurisdiction over traffic offenses. Probate courts were handling traffic cases back when it was known as the Court of Ordinary. Since that time, a lot has changed. Most of these probate courts now have a solicitor or an assistant district attorney who prosecutes these cases in an effective and efficient manner. These probate courts are operating in a manner that is cost-effective to the taxpayer while being mindful of public safety and the constitutional rights of the defendants. I think we're all in agreement that we don't view all traffic violators as criminals, nor do these violators view themselves as criminals. However, when these individuals break the law, the courts must address these violations. The court must be able to address these violations in a sensible manner that includes a practical punishment for such offense that guarantees the court's ability to enforce its sentence. Our council feels that any type of reform must take into consideration the enforcement mechanisms that the court would need to ensure compliance with its sentence. I think we would all agree that the enforcement aspect is key to enabling the court's position to ensure public safety when handling these violators. As this process moves forward, we feel the General Assembly should note the concerns of the courts with regards to enforcement and compliance, as should you note the concerns of the hundreds of thousands of Georgians who drive to and from work, school, or church every day. Their opinions have been documented by Travel Group's AAA Foundation for Traffic Safety in a research report in April of 2009, which stated citizens and drivers are concerned about their safety when on the other road. The report states Americans are very concerned about aggressive driving, at least when it's done by the other driver. A 2005 telephone survey by ABC News and the Washington Post found that when asked of the several potential threats most endangers your own safety on the road, 32% of respondents identified aggressive drivers as the major threat, yielding just as many responses as drunk drivers and nearly 3 times as many responses in any other item that was asked. The overwhelming majority of the respondents to the 2002 survey by the National Highway Traffic Safety Administration reporting having felt threatened by the behavior of other drivers at least occasionally in the past year, and about 1 in 7 reported feeling threatened by drivers weekly or more often. In a 2002 telephone survey by the Pew Charitable Trust, 58% of respondents reported they often saw drivers who were aggressive and reckless. With this many citizens arguably feeling unsafe on our roads and more concerned about their fellow drivers, it is more than imperative not to drastically minimize the punishment for violating traffic laws, especially those of a moving violation. Currently, most traffic offenses are considered misdemeanors punishable by a $1,000 fine and 12 months in jail if convicted. As Mr. Spahas alluded to, the courts can suspend a violator's driver's license for failing to appear or issue a bench warrant for the violator's arrest. In looking at this, our council will be the first one to state there is room to rework the maximum sentence on a non-arrestable traffic offense, while we would also support more options to guarantee compliance of the court sentence, whatever that sentence may be. The various classifications of the court, municipal, state, and probate, along with the prosecutors, have been working on various proposals, which you will hear about more shortly, to address the changes that are needed with traffic cases while being mindful of public perception, public safety, our state constitution, and the violator's constitutional rights. It is also important to remember the effect that drastically reclassifying the sentences on traffic offenses could have on the collection on fines and fees. While our local governing authorities are often concerned with the amount of fines and fees collected, it is important to remember that on top of the fines collected by the courts, millions of dollars each year are collected by way of traffic citations that go to fund various projects like the State Indigent Defense System, driver's education, and the Crime Victims Assistance Program. Looking at the Crime Victims Assistance Program, for example, district attorneys all across Georgia use these dollars to fund positions for victims assistance coordinators who work primarily with victims of crime like domestic violence. The district attorney's office uses these funds to help subsidize centers and outreach programs that specialize in assisting battered women and children who have been molested or neglected. Any attempt to hinder the court's ability to collect a fine that is owed for a traffic violation or hinder its institution of punishment will not only significantly result in a net loss of revenue for our local governments, but it would also result in a net loss of funding for people who cannot afford an attorney in a criminal action, and for people that you and I may worship with, work with, or fellowship with, who have been physically or sexually abused by a loved one and cannot get the shelter or counseling that they need to cope with during this tragedy. As you can see, reforming Title 40 has implications across a broad spectrum. Through this reform, it is imperative we feel that the probate courts remain strong, the general public remains safe, the Constitution remains solid, and the violators remain accountable. There is no need to tear down the house to fix a leaking pipe. We feel we need to identify the problems and address them in a practical, proactive manner. Council of Probate Court Judges stands ready to work with your committee, our fellow judges, and the General Assembly to institute practical reform. Thank you for your time.
Judge, thank you for testifying today. I guess we're going to hear from Judge Jim Anderson next. Jim?
Good morning. I can't tell you how appreciative I am personally, and the Council of Municipal Court Judges is, and all of our judges are, to be able to present our views and be a part of this process. Judge Kent Wickham, who is our president, sends his regrets this morning. He could not get out of his regularly scheduled court appearance, so he's out serving the public today. I'm in his stead. I'm the president-elect. I'm going to try not to reiterate what everybody else has said, and because your time is valuable and we have so little of it. The municipal courts, there are approximately 400 of them. Between the municipal courts and the probate courts, that's where the majority of all traffic cases appear in Georgia. Municipal courts alone, over 1 million, between 1 million and 2 million traffic citations a year. My particular court, Sandy Springs, 30,000 a year, traffic citations only. This is, to coin a phrase, where the rubber meets the road in the probate and magistrate and municipal courts for the majority. All courts of every class can hear some type of traffic. We understand, we have not heard from our judges, the municipal court judges, a big hue and cry for reform. But we're our perspective only, and we recognize that other classes of courts, other stakeholders, if you will, have their perspectives. They're not necessarily the same. So we understand while we may not be banging down the doors for reform, others have legitimate perspectives and concerns, and we respect that and intend to and will continue to work collaboratively with all folks to try to bring forth reform which appears inevitable and we hope will be meaningful and productive. We have some concerns and we have some suggestions. Some of the concerns we've heard from already. The judges and prosecutors have already set forth some of our concerns. So I'm not going to say them again. I can endorse what my colleagues have said already. But here's my concern, and I expressed this concern the other day at another meeting on this very subject. Let's talk about traffic for just a minute. What are we talking about here? The offenses that we're talking about, for the most part, the minor offenses. The failure to yield, the following too close, the failure to maintain lane. What are we really talking about? We're talking about the things, the offenses, the minor offenses that cause over 200,000 motor vehicle collisions in this state every year. Of the 250,000 total, and I'm going back only to 2008, which is the latest available data. These minor offenses cause 80% of all traffic accidents in Georgia. Governor's Office of Highway Safety, that's their data. DUIs, I'm not diminishing DUIs here. Don't ever think that I'm not serious about DUI. But in perspective, DUI accidents about 3.6%. Fatalities. 2008, total of 1,493 traffic fatalities in Georgia, represented in 1,400 fatal collisions. DUI accounts for 128 of those collisions. By comparison, just failure to yield, driving on the wrong side of the roadway, that's been brought home to us recently. Following too closely, failure to obey a traffic control device alone counted for 413 fatal collisions in 2008. And these numbers don't count the primary cause of fatal collision, speeding, or primaries. Loss of control, that category. I'm not sure what that means. It could mean failure to maintain lane. It could mean just running off the roadway. Those total 950. So while DUI counts for 9% of the fatalities in Georgia, these, quote, minor traffic offenses that appear on statistics as minor traffic offenses, they are killing our families. They are causing billions of dollars in property damage. They are injuring us and our families. We cannot take this matter not seriously. We must treat it seriously. This is why we are all here. We're embarking on a course that has, well, why are these important? Other than for just the basic public safety. What are we talking about? Disregard of traffic laws is endemic. You all drove here today, more than likely. You witnessed a dozen traffic violations, I'm sure. You were tailgated. You were cut off. Somebody in front of you failed to stop at a stop sign. Somebody in front of you failed to use their signal when they changed lanes. I know it happened. It happened to me. It happened to everybody in this room. Why? I'm not a psychologist. I haven't done any studies. This is my intuition, and I'll categorize it as that, and it's my personal intuition. It is not the position of the Council of Municipal Court judges. The public too often views the traffic laws as something for the other guy to obey because I'm a great driver. And I can see beyond the stop sign, so I don't need to really stop. I'm a good driver. I can go 15 miles an hour over the speed limit because I've got a great car and I can do it and not hurt a soul. So what difference does it make? The laws are seldom enforced, not because the police officers and State Patrol don't do a good job. They're just not enough of them. So your odds, not you, because I know y'all obey the traffic laws perfectly, but the odds of the average motorist getting caught speeding are infinitesimal. You know where you can run a stop sign and not get caught. The risk of being caught is minimal. The consequences of being caught, for the most part, are minor. So, in short, for the driver, for many drivers that we see as municipal court, probate court, and all other judges, we see drivers' histories a quarter inch thick, going back 20 years of just infraction after infraction after infraction. These people view traffic laws as a nuisance. And they're the ones that are killing our families. So we're embarking on a course here which has the potential to send the message to the public that we really, really don't care too much about traffic laws. You're right, they're really just a nuisance. So let's don't go down that road. Let's don't make their perception reality. We're concerned about public safety. We're concerned that what we do may encourage violations rather than discourage, which is what the laws are all about. Now, we have some suggestions. Those are my concerns, and bear with my passion because I didn't ask for this job because I didn't care about what I was going to be doing. And suggestions. Let's keep, I think I'm going to echo what has been said already here. Keep the changes that we make simple and incremental. We've got an established body of law. If we make wholesale changes, we're going to have to reestablish a whole body of statutory and appellate law to work around this. It's going to be a tremendous process. If we do a wholesale work outside all boxes in trying to reform, I can see no traction among any of the people I've talked to for decriminalizing traffic. And our council does not support decriminalizing traffic offenses. We agree that there may be some non-moving traffic offenses, equipment violations, cracked windshield, that may be better handled with fine only, but we do not support a wholesale move of moving violations from the potential of incarceration to fine only for lots of reasons. What we are suggesting and is to look at the creation of a new class of offense in Georgia called the petty offense. The petty offense came over from England. It is recognized by the United States Supreme Court, as has been said, as the demarcation line between the right to trial by jury and not having the right to trial by jury. It is the 6 months or less potential incarceration. There's plenty of state Supreme Court law saying that in municipal ordinance cases, particularly county ordinance cases, you do not have a right to a trial by jury because these are petty offenses. We need to look at that. So if one of the things we're talking about changing here is getting these cases out of the state and superior courts, then this may very well be the way to do it. If we start backing down on some offenses, we need to create some new offenses to backfill, particularly when you have a very minor traffic offense that causes serious injury. We have a felony offense now, serious injury by motor vehicle. We have a vehicular homicide, but we have no misdemeanor serious injury by motor vehicle. And that's where most of the felony is only for reckless driving and DUI that causes a serious injury. We have no separate category for causing a serious injury by a misdemeanor traffic violation. So a failure to yield is a failure to yield is a failure to yield is a failure to yield under the current law. Following too closely is the same, and those are the ones that put people at shepherds. Potentially create a new traffic offense that couples driving on a suspended or revoked license with another traffic offense. They're not coupled at this point. We need to maintain the ability of the courts to enforce their fines and fashion appropriate alternatives to fines and imprisonment. If you do away with the potential for incarceration, you do away with probation. If you do away with probation, you tell Jim Anderson, I can't sentence you to community service. I can't give you probation. I can't supervise you and give you a payment plan so you can pay your fine. I can't require you to go to defensive driving. If you're 19 years old, I can't require you to write a 500-word essay on the dangers of bad driving without probation. I can't impose a curfew on you. I can't restrict your driver's license along with your parents to certain times of the day and certain activities. Do away with probation. You do away with all my ability to craft creative solutions to bad driving, particularly among young people. The law of unintended consequences was already mentioned here today. Let's proceed carefully. The law of unintended consequences does apply. It will apply. We don't know yet where. We will, and we pledge to help you seek the correct answers to the problems, to the extent that problems exist. I want to thank you on behalf of the council, all municipal court judges, and President Wickham, who regrets he couldn't be here. Thank you very much.
Thank you, Judge. We appreciate your comments. I got us off to a slow start here in terms of my comments, and we've gotten slower, but with good information. So we highly regard that. We just ask you to be sensitive. If it's already been said, we don't need to obviously go back over it again. But and unfortunately, David, is it Judge David Darden?
Right.
I'm sorry.
Yeah.
That is you. Yeah.
That's
Okay.
me.
I'm sorry, Judge. You happen to be up next after I made that comment, so
Right.
the pressure's on you.
So I get it. All right, and I'll be careful to understand that. So I'm assuming we've talked about obviously that decriminalization we feel should be off the table. We should avoid a process which would bring us into trying to amend the Constitution. Having said that, I'm going to start with a couple of things. I do represent the state courts. The issue that is before us, and I've been asked by the other judges to take these topics up. We've tried to split these up. And what I want to talk about is, before we start talking about the solutions, we need to examine what the problem is and what the expressed problem is. And my understanding is that the procedure had its beginning with concerns that superior courts are being burdened with these minor traffic offenses with the defendant requesting a jury trial, which under the Georgia Constitution they have a right to. And that the feeling is we should try to find a way to alleviate the caseload in superior courts from having to deal with cases, minor traffic offenses, for which a jury demand has been made. It's our view under the Constitution of the state of Georgia, if imprisonment is an issue, if it is a possibility, then the defendant under the Georgia Constitution has a right to a jury trial. If your liberty can be taken, you have a right to a jury trial. So that's what we understand, that this was sort of the genesis of this procedure. So if that is the problem, relieving superior courts from jury trials in these cases, first you should know it's not a problem in 70 counties, because in those 70 counties we have a state court, and we are a jury trial court. unlike some of the other courts here. State courts are empowered under the Constitution to conduct jury trials, and so those cases, when they come out of probate or municipal courts with a jury demand, in those counties where we have a state court, they do not go to Superior Court. They go to state court, and they're handled there. And you should know, according to our research at the state court level, those cases that come into the state court with a jury demand very, very rarely result in a jury trial. Under 1% of the cases that come into state court with a jury demand actually end up with a jury trial. The cases are resolved short of jury trial. So if that's the problem, if the problem really at its genesis is keeping minor traffic offenses off of jury trial calendars in Superior Court, first of all, state courts in 70 counties, that's not a problem. So our proposal for the legislature is that there are 2 local control solutions to address the issue before we even get to reclassification of minor traffic offenses. First is create state courts in those other counties to be able to take some of these cases off of Superior Court. And I know there are expense issues, and we've talked to ACCG about this, and one of the things that can be done at the local level through local legislation is creation of circuit state courts or multi-county state courts. That is permitted under the code at this point and should be encouraged or made a priority. ACCG is supportive of that. And the way the expenses are saved at the local level would be 2 or 3 counties to go in together, create a state court. That state court would have jurisdiction in those 2 or 3 counties, and the state courts would sit in each of the counties to take care of these cases. There is precedent for that. Forsyth County and Cherokee County had a multi-county circuit state court until a few years ago, when those counties grew to the size that they just had their own state courts. There is precedent, there is statutory authority for it. The other, what we're saying is local control solution. Permit and encourage Superior Courts to use existing legislation to seek assistance from other judges to handle the minor traffic offense calendars. These are local court practices that Superior Courts can create a minor traffic offense calendar. They can use assisting judges, magistrates, probate court judges, state court judges. The statutory authority already exists for for Superior Court judges to seek the assistance, and there's a formal process that is undertaken you can foresee where a Superior Court would create a minor traffic offense calendar. If they used a state court judge, then that judge would be empowered under the Constitution to take that case all the way to trial, jury trial. So those are some local control solutions, which don't really impact expense. They also avoid the problem that my fellow judges have mentioned with regard to collectability. With reclassification of minor traffic offenses, what I call below the line, which means no incarceration, you run into collectability issues, and we can't. We're having a hard time measuring that metric, but it's big. If you take away incarceration, then you take away probation, you take away the ability for people in a hard economy to have time to get their fines paid. They just throw up their hands and they walk away. So that's a big issue. So in the event the General Assembly elects to sort of bypass those local control solutions that we think are workable, if Title 40 is overhauled with regard to the minor traffic offenses, it would require, and they've talked about the forest, and I'm going to talk about the trees. It would require 2 tiers. There would be a tier below the line, and there would be a minor traffic offense which would not have incarceration. Why is that important? Because without an incarceration, there is no right to a jury trial. And I would add, there is no right to indigent counsel. So there are some savings, more so with the removal of right to indigent counsel than the right to a jury trial. We've already discussed, if we're trying to save jury money by this, that's illusory. Very, very, very few of these cases actually end up in front of a jury. But if we do draw a line, and under that line would be the cases that do not have a possibility of incarceration, then our recommendations are make that line very low. There should be very few offenses that are under that line for the public safety issues that have been addressed and candidly, for the collectability or solvency issues with regard to the fines. We need to understand there are people with minor traffic offenses that are going to need time to pay. They need to go to defensive driving. They need to do community service, but we don't have that option. I think we need to consider, and this is a critical issue that we've raised, a failure to maintain lane is a standalone offense if you made that a minor traffic offense under the line. We need to recognize that if someone is driving under the influence of alcohol and they failure to maintain lane, they're going to be charged with both of those offenses, one of which would be have no incarceration. We don't think that that's the proper way to proceed. If the under-the-line offense is committed at the same time or in conjunction with an offense that would be over the line, say DUI, then that under-the-line offense should now be above the line and a misdemeanor. The way you do that is you create a statute that says a commission of what I'm calling minor traffic offense in conjunction with a traffic misdemeanor is a misdemeanor. So that's a catch-all that brings those minor traffic offenses, if they're committed, say, in conjunction with a DUI, then that statute is violated and it is a misdemeanor. And that makes sense from a public safety standpoint. Garden variety, failure to maintain lane, maybe if you decide to put that under the line, okay. But a failure to maintain lane by a driver who is under the influence of alcohol is more serious and should be treated as a misdemeanor. So this would change that a failure to maintain lane is always a failure to maintain lane and treated in the same way. So the analogy is the statute that says possession of a felon while in commission of a crime. That is a felon. So it brings those things above the line. I think that is, you have to have that. You have to have that so that you're able to address public safety concerns. Also, accountability courts. As you know, with a misdemeanor, the maximum sentence is 12 months. If we only have a single count, it's 12 months. But with a serious DUI or a multiple DUI, someone's had two or three DUIs in a short period of time, they need to be in an accountability court. The reality is, if they have a DUI count and a failure to maintain lane, and that failure to maintain lane is not punishable by incarceration, the maximum sentence is 12 months because there's only one misdemeanor. So we need to bring that below the line offense and make it a misdemeanor if it's committed with a misdemeanor. Now we have 24 months, and now accountability court is more feasible. We have to have more than 12 months for accountability courts to really work. We need to address multiple offenders under minor traffic offenses. If someone has had a failure to maintain lane, 4 of them in the last 24 months, I submit that should not remain under the line. That should not be a fine-only offense. As has been mentioned earlier, you've got an offender who's treating failure to maintain lane as a cost of doing business. You know, we need to move that above the line if there's a certain number of offenses within a defined period of time. And candidly, we need to address accountability. We need to address collectability issues, as we've mentioned earlier. The ability to have probation is in lockstep with the ability or the incarceration being part of the offense. So, in summary, when we talk about the proposals, we think there are 2 local control best court practices solutions that may obviate the need for wholesale reclassification of minor traffic offenses. But if that is not the case, if the General Assembly chooses to move forward with reclassification, the line needs to be very low. There need to be very, very few offenses that are under the line, and they need to be brought above the line if committed in conjunction with a misdemeanor or in a multiple offender situation. Try to be brief, but I did submit a memorandum which has more detail about these issues.
Thank you, Judge Darden. That was brief and to the point. Judge Gary Jackson from the Atlanta Municipal Court.
Thank you. I apologize for my delay, but I had a court this morning at 8 o'clock with both traffic criminal and civil cases, including red light camera and parking tickets, which I'm sure none of you get. Let me first introduce myself. I'm Judge Gary Jackson. I'm a member of the Municipal Council's board, and I've served as 11 years as a judge in the Atlanta Municipal Court, formerly on the City Court of Atlanta, which was a limited court of state jurisdiction that had jury trials. Before that, I began my legal career as an assistant in the Legislative Counsel's office, so I know how hard all of you work and how little you are compensated. It's an honor and really a thrill to address this body, Mr. Chairman and members. And I want to echo Judge Darden's comments. I will note there are already 7 traffic misdemeanors which are fine only, HOV, texting, things like that. But the issue of collectability seems to be arising in all of these conversations. And since I was a collection lawyer for 25 years and teach other judges at the Institute of Continuing Judicial Education in Athens on the collectability of judgments, it fell to me to look at this issue. Let me first point out that courts do not exist to create revenue. It's improper, it's unconstitutional, it's unprofessional. Nevertheless, we do look at what we do, and the fact that there are many people who just want to pay the fine and be on with it. There's some that want to and are not able to, and we put them on probation, which, as you've seen, is vital. There's also a group of people who are just not going to pay the fine. And in addition to the revenue effect that it has on our cities and counties, it breeds disrespect for the court system. So I looked into how we collect these unpaid fines, and I have a handout which I've given to the staff. There's one for every one of you. And you will see in the first tab is the law on collection of judgments in Georgia. Believe it or not, you can issue FIFAs, you can garnish, you can seize property. All of those are very, very expensive. They're time-consuming and highly burdensome on a limited staff of prosecutors. One thing I wanted to look at was the easiest way to collect the fine with the least expense, a new way that would not be an unfunded mandate to our counties and cities who support our municipal, probate, juvenile, and other court systems. Right now, there are about 14 states in this country. If you have an unpaid fine, those courts can send that fine information to their revenue department and intercept the driver's next year's income tax refund. If you're in California, for example, and you don't pay a fine, or you're in Wisconsin or Arizona or Missouri, those courts send in that information. Last year, Wisconsin collected almost $21 million in unpaid fines. And we're not talking about depriving somebody of their rights. They have been to court. There's a judgment against them. It's not paid. Now, they have systems in place in the event of identity theft or mistakes by the clerk, and those are all in the systems. There are 14 states that are doing this. I looked at 4 states at random, geographically different than Georgia, and with different demographics. And you'll see in the table of contents, Arizona's collecting $18.6 million, California over $10 million, Missouri just started over $1 million. These programs are extremely successful with a very limited amount of cost, and we do the right thing. We make our judgments enforceable, we collect them, we breed respect for the court, and we don't create a lot of expense. Well, that's fine in concept. You've got 1,100 courts in Georgia. How are you going to do this? Well, first of all, we don't need to reinvent the wheel. Right now in Georgia, we intercept state income tax refunds for 8 different reasons. Welfare fraud, unemployment fraud, things like that. If you look in the statute, 487-164, it lists all the things that we do. So we're not talking about sitting down to a restaurant for the first time. We're talking about adding another entree to the menu. But still, you got 1,100 courts, and I don't think the Revenue Department wants to answer 1,100 different courts sending thousands of tickets. The easiest way, I think, to do this is to look at the existing system. Every court in Georgia right now sends money to the state for the add-on fees, which I personally abhor, but nevertheless, that's what we have. They do it through the Superior Court Clerks Cooperating Authority. Every month, the City of Atlanta, the City of Sandy Springs, Cook County, Probate Court, they're all sending money up the stream to the state. And the state keeps track of it. If you don't send it in, you're going to have somebody knocking at your door with a summons or a question. We could use that existing system and look at the courts and give them the option, do you want to participate in the Intercept program? There is an expense in terms of assembling a database. In the 4 states I've looked at, it's somewhere between $4 and about $8 or $9. So let's say you're the City of Atlanta and you pick 100 tickets that you want to collect. Look at the zip codes, look at the drivers, where they live. Chances are if they're driving a new car, they're working, they get an income tax return. Let's say hypothetically it's $5 a case. So you pick 100 cases, you send $500 into this database. Well, the odds are since our average fine is $200-300, if you collect one or two of those tickets with an income tax refund, you're in the black immediately. And the states that are doing this, once you get that first snowball rolling down the hill, it's a self-sustaining procedure. You make it voluntary. No court's forced to do this, not an unfunded mandate. And on the back end, when you make the intercept, you add that $5 or $6 that it costs back on to the offender. The offender's going to pay for this. In some states, they charge a percentage. Most states charge a flat fee, $5 or $10. So it's user optional and offender funded. You could go use the Superior Court authority as a clearinghouse. You submit the information. Now, there will have to be a cross-match. We use license numbers. Revenue Department uses Social Security numbers. We know that under Real ID now, somebody has to sit down and cross those numbers. That's part of the expense. Come April 15, that taxpayer gets a notice, you've got less money coming. If you have a complaint, call us, call the court, but we're holding this money up and we're going to pay that court out. And they simply deduct that money, and then the Clerk Superior Court authority sends a notice to, say, the Atlanta Municipal Court, well, whatever money you're sending in this month, deduct $12,000 for these defendants. This is what the set-off was. You're not even writing a check. You're just sending out the computer information. Our clerks apply it to these tickets. We send in less money. The thing's balanced. It's a very simple system. And in the states that I've examined, and you have not only the listing of the states, you have the data, the personnel that you can talk to, the actual statistics, and believe it or not, some of these states have put their user manuals online. We can simply copy, if that's legal, what California's doing, what Wisconsin's doing. The opportunity for return is tremendous. Now, of course, the big question is, how much is out there? Well, it's substantial. I'm really somewhat hesitant to find out the exact number. But I submit to you, we have more cars in Georgia than Arizona and Wisconsin. I would think in the first 2 or 3 years, we'd be getting several $1 million, and probably in the second or third year, we'd be over $10 million for a self-sustaining program that would build respect for the courts and help our cities and counties. This is the easiest thing that I've seen. I am surprised we're not doing it already. Now, somebody has to figure the actuarial amount. I've got to get together with Mr. Bray back here and the Revenue Department people and the IT people as to how we're going to do it. But if 14 states have done it, and we're doing it now for 8 other reasons, it seems to me this is something we ought to look at. And since I'm the collection lawyer and collection judge, it kind of fell to me. So I would hope that we would look at this. Our city of Atlanta, by the way, is meeting tomorrow to talk about taking our uncollected judgments and putting them out with private counsels as associate solicitors under strict ethics requirements. That's one way you can do it. But this is a statewide system that basically requires no additional personnel at the local court level. And I think it would be extremely profitable. And I'd ask that you members look at this carefully. And that's all I want to say. And I know we're now at questions, so if you want to pepper me and then work back up the line, that's all right too.
Well, thank you for all.
Let me add that the other councils seem to support this because this affects every court in Georgia, not just municipal, probate, juvenile, magistrate, superior, and state. They all seem to be, and ladies and gentlemen, I believe we're all kind of looking at this as a way to support the counties and cities that support us.
Well, thank you for your comments, Judge Jackson, and for all the rest of the members here. We are well behind our schedule, and I should have learned that. Well, you guys can't bill this anyway, so I should have started in the afternoon with the. Yeah. All right. No more lawyer jokes, because obviously when you love them and when you need them. So anyway, look, let's go to questions on this, and if you got a question for any member of the panel at this point in time, why don't you just push a button and we'll get you going here. Okay, Chairman Powell.
Yeah, I guess my question is for Judge Darden. I understand what you're saying as far as very few cases go to a jury trial, but don't you find in your experience that to some extent people demand a jury trial either to delay their case or to do some forum shopping so that they can jump out of municipal court into state court or superior court? Or
We do see that. Yeah, I do think, and that's really where I'm talking about, that if the idea, the solution for that is to remove incarceration as a possibility. And so there's a trade-off. There's a trade-off that those cases do not move to another court. They get stuck. They're in one forum, and then you have the problem of collectability. But you're right. They do. There is forum shopping. I prefer to think of it as solicitor shopping rather than judge shopping, since I mean we try the cases. You know, the jury decides them, but another shot at another solicitor. But that's a trade-off.
Well, it's not so much the solicitor. If you've got a hanging judge as a municipal court judge and you're going to plead it out in
Right.
state court,
You want to get out of there.
Yeah.
Right. That's true.
Chairman Golick.
Thank you, Mr. Chairman. To Judge Darden as well, we've seen a sort of two-tiered analysis. One was on the issue of the Superior Court judges, having to handle a red light, jury
Right.
trial. I think my sense is that there's relative universal agreement of the absurdity of that, and that's, in my opinion, not the highest and best use of that public resource. Right. And I was intrigued by the possibilities that you talked about in terms of intergovernmental agreements, multi-county state courts, right, or circuit state court, however we want to define that, if it even needs a statutory change. I don't even know, but we can find out.
It really doesn't.
And then we got into the conversation about, and then getting into reclassification.
Right.
And I think, and I'm going back to the recommendations and the discussion of the Criminal Justice Reform Council of last year, and that's of course my relationship to this issue. And it was called for as a possibility by the council. What I'm interested in learning more about, candidly, is, and you talked about the line of where it is fine only and where it's the possibility of incarceration as a criminal misdemeanor, 12 months or $1,000. And of course, it's a function of defining what that line is. And I mean, the first thing that I think about, of course, is equipment violations. What else, just for the familiarity of the committee, what else are we talking about as possibilities? Now, anything you may say doesn't lock you into anything. Let me just make sure that's clear. But just so the committee gets an idea of the breadth of what we're talking about. I mean, we have the obvious public safety issues, DUI and reckless driving and so forth. What are we talking about in terms of, other than equipment violations? I'll put down here.
Right.
What's hovering, in the middle there that poses a judgment call?
Right. And this is a lot of the work that our group has been doing all through the summer. And
you may not be ready to talk about it.
Really,
if not, that's fine.
Probably not. But
okay.
I would say, generally speaking, we all recognize if we have a tier system, you got to draw the line somewhere. Somebody's upset about where the line is.
Right.
Our general consensus is the line should be very low because of these public safety concerns. And it may be that it should be drawn at the line between equipment and moving violations.
And Judge, we have 7 right now that are fine only, still
Right.
misdemeanors.
Yeah.
The General Assembly's already done that. Seatbelts, HOV, texting, open container, hot lanes, and I think there may be one more. The General Assembly's already done that.
They've done that with some of these offenses. I'm not sure texting. I personally agree that should be below the line. I actually think it should be brought above the line, particularly in conjunction with more serious offenses. But anyway, so those are some things. But I think the line between equipment violations and equipment type violations and moving violations is, if we're going to do it, that's a safe place to start. And I might add, Representative Golick, we talked about this the other day, that it's always better to have the line low. If after practices and we see what's going on, you can move the line up. But if the line is higher, moving it lower is very difficult.
Do you see, just one brief follow-up, Mr. Chairman, and not necessarily Judge Darden, but anybody on the panel, other states have approached this. We certainly would not be the first, and we wouldn't be the last. And if you can say now, if not, I understand it's only the middle of September and we have time,
Right.
is to take a look at what other states have done and where they have succeeded, where they have failed, and any mistakes that they've made that we can potentially learn from in order to perfect it. Because beyond the Superior Court issue and the reclassification, there are some efficiencies that can be generated within the system if we make certain changes. The collectability issue is intriguing, to say the least.
And one of the things we've
And-
done on that, too, we've talked about reworking and improving what used to be the old TVB, Traffic Violations Bureau system, for payable offenses, making those easier and to pay. And that affects collectability and is a reform that is needed. And that would affect some of these lower level offenses. The collectability of those, the fact that people are just going to get those paid easier, and that sort of thing. But I would say there's not been a consensus among our group, and everybody can speak for themselves, about exactly where the line should be drawn, other than a general feeling it needs to be low and probably somewhere between the equipment violations and moving violations.
I would encourage you, the group, and I realize driving consensus amongst the various judicial councils may be challenging, it may not be, depending on the issue, but I would encourage that consensus, and I would also encourage you to take a look at the other states and see what we can learn from them under the category of not reinventing the wheel. There may be some models out there, some newer, some older, that we can, I wouldn't say necessarily mimic, but at least
see their
get a framework on it that might be successful, we might be comfortable with. Thank you. Thank you, Mr. Chairman.
Sure. Anybody else? Any questions? I see the light on 15 is on. Okay, I have a question that just occurred to me, and this is a non-lawyer based question, so you have to take it for what it is. Judge Anderson, you mentioned the coupling idea with something that's below the line, and there's another offense that does occur in the same situation above the line that you move the offense above the line. You all are supportive of that concept and everything, I assume.
That gives you more time to work with, especially
in accountability.
Exactly.
And the other day, Judge Darden, I think you mentioned that just for the committee's benefit in terms of the numeric associated with the metric associated with this, that the very small percentage of the cases actually go to jury trial right now, which I think you said 1%. If
Lower
you're
than
not
1%.
Lower than 1%.
We did a study. I think we've done about 5 or 6 state courts. We tried to get suburban, urban, and more rural counties. We did a study of the number of payable offenses. Those are the minor traffic offenses that come in the door, and those that actually result in a jury trial. And I think in Cobb County our number was 32,600 come in the door as payable offenses that resulted in 2 jury trials out of 32,000.
How much does a jury trial cost?
Well, the judge gets paid either way, so. But there, obviously there's expenses.
Always.
There are expenses with regard to obviously the direct expenses,
Yeah,
jurors.
jurors and stuff
Right,
like this.
and,
Yeah.
but there are sort of incidental or incremental expenses. Lost courtroom time, if you can think of it that way. Jury trials expand; they take up time, and that's time that we're not able to move other cases. So it's hard to put a hard number on that, but obviously there's hard expenses, and then there's lost opportunity expenses.
Okay.
But 32,000 came in the door, and 2 got, and that was only 2 resulted in a jury trial. So.
It would be good to understand statewide, kind of where that
Right.
that stands, particularly in the area that do not have state courts, and
Right.
What happened in those situations. Okay, are there any other? Well, we got a question from Representative Powell.
Thank you, Mr. Chairman. I was resolved not to speak this morning and address y'all, but the question that just came up about why so many people don't go to jury trial, and it begs to my thoughts of dealing in this committee and dealing with the public for so long. And I listen to all y'all, and I truly do appreciate, and I think your hearts are in the right place, because y'all are the judges. Y'all make your living doing this. The gentleman over here was very right. We've got to have the reason we pass laws is to create a certain level of behavior to keep people from running over people on the highways. But unfortunately, I'm afraid that probably one of the bigger problems that we have today, and it's not just started, but it's that level of disrespect for the court systems, for law enforcement as a whole. Every time a law enforcement officer stops somebody because they've got a nick in the windshield, and you know that pretty well what that that offender might say to that. And then they get charged with what some of us as non-lawyers, we call it stacking charges. Stack them up on them, pick their pocket. That's an attitude out there. But as I listen to all of y'all, money seems to be a predominance of this. And I think that the public's more interested in justice rather than them being the cash cow.
And that's why,
quite frankly, I was
don't exist to create
quite
money.
frankly, I was sort of amazed and look forward to seeing your presentation about using the IRS, the state revenue, to collect fines. That will almost ensure everybody elected to get run slap out of office, quite frankly. But I think it's this level of respect. The one thing that I did hear that came out of this crystal clear with me was maybe a split system of petty offenses. Put a fine out there. There's very little judicial, there's so much judicial inconsistency. Depends on where you go. Depends on where you get stopped. Depends on what solicitor you go to. Depends on what court you go to. You can get fined X number of dollars for the same offense depending on the county. Most people I know that get a speeding offense, they don't mind paying the fine. They ain't going to go to pay it. They're not going, because it's in their mind that they've got to hire a lawyer to represent them in court. That's how complicated the system's got, and it shouldn't be. If they're innocent, if they want to take it to trial, they ought to be able to. But the judiciary themselves, I fear, have been a lot of the problem. When people go to this, most people I know that get a speeding violation, quite frankly, they'll pay whatever the fine it is if you'll lower it to below 14 miles an hour so it doesn't go on there. But then when a kid goes over to the Gwinnett County Traffic Court and he goes up and he asks the solicitor in front of the judge, could he lower it? He was 5 over that, wanted to get it to the 14. And the judge tells that I'll just dismiss the charge if you'll pay a $500 fine and you'll enroll in a particular driver improvement course. Let me tell you something, folks. There's where a lot of the problems with respect for the system is. And, quite frankly, I appreciate y'all's attitude, especially this gentleman right here. But we need a simplified process. If this is your violation, pay your fine. You don't need all these add-ons and such like that, because I think you said average fine was $200 to $300.
It's not so much the fine,
It's the
Representative. It's just that with every traffic ticket, you take 45% and add $3. $100 ticket's $148.
Yeah.
And those are the surcharges passed by
By the General Assembly.
Exactly.
General Assembly that right now have to fund the state budget. And those surcharges are not separated. As you know, they collected $30 million for Joshua's fund, Joshua's Law, but they only spent $22 million for young driver training in high school. And I know when I was a lawyer, if I collected from one client and gave it to another, I'd be in big trouble. But in that state that we're in, this is what we're doing.
All right.
And I will tell you this, I don't engage in that conversation because part of my job is to protect the safety of the motoring public. And you don't want to reduce things. You don't want to keep things off people's records because that puts unsafe drivers on the road. It is what it is, and we try the cases. And we should try the cases. And having just been trained for commercial driving, we don't mask anything. We're not supposed to. But I will agree with you that may very well go on. But it doesn't go on in courtroom 6D. That I can promise you.
I'll be sure I don't.
Oh, you won't.
I'll be sure I don't visit your court.
Well, as far as parking tickets, they're civil and you have immunity while you're in session.
I would say on the financial issue, we're all uncomfortable talking about that. In our meetings, we all talk about it. We don't want to talk about that. It's not our concern. It's not our issue. The only place that it does sort of impact us is when we see offender A who is struggling to get his fine paid, and we're giving him time, and he's good faith getting it done, and offender B is not. That's really where, on a daily basis, we feel the money. That's not our job.
All right.
But you would agree, Judge, there's a group of people that just won't pay no
Right.
matter what you do.
Right.
Yeah.
So
That's what this is addressed, the recalcitrant motorists who simply will not do anything. And we don't want to put these folks in jail because that's a bigger burden to the taxpayer.
Well, most people, I would suspect that most people who can afford to pay a fine if they're facing the loss and suspension of a driver's license, they will pay.
And many judges,
The
I
bigger
will
problem
say-
that we've seen on this committee over the years in these all the statutes that we passed about getting tougher on this one and that one is that we make it so cost burdensome for that they've made a mistake.
Right.
If they can't get that license back, they're just going to drive without a driver's license, and to
You
me
have
that
to-
makes
you have
them
to
even
fix
more
it at
dangerous.
that point. Yeah. And most of the state courts, I speak for these other courts as well, if we get to a point where someone in good faith can't pay a fine, we don't put them in custody. We allow them to do community service in lieu of it. So,
And we can't put them in custody.
No.
Under the law. It's
So-
unconstitutional to put somebody in jail just because they're unable to pay. But if they refuse to pay, no matter what you do, then we have a choice. Either we put them in jail, which we don't want to do, or we try something else as a last resort. And that's what this is, a last resort where everything else fails. And that's why I think this may be the only way to go.
I think you'll find there's a lot of us, especially on this panel around the state, there's probably hundreds of thousands of dollars in fines that have been put for community service just for the sole purpose that the violator couldn't pay. I think you'll find a lot of judges are mindful of that.
And I can tell you that's something that we struggle with in our jurisdiction because we see our dependents, they talk proudly about their tax returns and going to Disney while they're not paying their fines. In treatment, in our accountability courts, they are walking away because that's something that they know my judges cannot put them at an added cost to the taxpayer in jail. We can't justify that. And if the taxes of sheriff's department to serve those warrants to take them into custody, this is absolutely flagrantly going on daily in every state court, in every jurisdictional traffic.
So as judges, y'all might agree that in this study on the Title 40, that we might be proper that we expand this, that we maybe look at audits about all those pots of money to see what retirement funds that are overfunded and what may or may not be necessary. I'm glad I could get a grin out of some judges. You know, most times judges sort of.
You're getting above my pay grade.
Yeah, mine too.
Well, I don't get above your pay grade. I just don't want too much money in your retirement account.
Well, there's none in mine. This is the board don't have it.
Well, I have an 8-year-old, and I'll never tap that retirement account.
Thank you, Mr. Chairman.
Thank you, Representative Powell. Chairman Golick recognized.
Thank you, Mr. Chairman. Just a follow-up and just to wrap up a point. The judges, I think, defended themselves pretty well on that their issue and their role is not as a revenue producer. They're there to serve a function. What that produces or doesn't produce over the course of time is none of their concern. They're there to dispense justice. And we talked about the figurative offender B just a second ago. It's the person who can pay but doesn't pay. And to Mr. Powell's point, which I totally agree with, that there's a fundamental lack of respect on the part of some individuals who come into contact with our court system. Those individuals come in there and flunk the attitude test immediately. An order of the court is not an optional, and I know we all know that, and I understand that. But if we don't act against those individuals and let them know that, no, you can't get away with this is not an optional, this is not I don't feel like this today. No, this is an order of the court. If we let that stand, then really what we're doing is we're tacitly, it's a benign neglect, really, is what it ends up being. I think any proposal that's out there that really isn't reinventing the wheel, we already have this mechanism with 7 or 8 offenses right now, or 7 or 8 issues, and adding that on, I think, sends a very clear message to the gentleman's point about the disrespect for the court system amongst those figurative offender Bs, that this is not an option. This is a requirement. And maybe next time, after that person experiences that little joy of having that interception or whatever it is, maybe the second time, because they'll be back, I guarantee you, and they guarantee you, that person will be back right in front of one of them, sooner rather than later. That next time, that ain't going to happen. That ain't going to happen, because that's the deterrent effect of that kind of mechanism. Am I sitting here endorsing that? No, because I've got to learn more about it. But it's not about the revenue. It's about the ability for respect to the court system and for court orders actually meaning something. And this is one possibility to go ahead and address that.
Thank you, Mr. Chairman. The only other question I would have, didn't we used to call these offender Bs scofflaws?
Yes.
basically.
They're still there.
This issue goes back, I mean, I come from the Philadelphia area, so, I mean, we used to have, and I've been in traffic court in Philadelphia.
I went to school
Was a
in
remarkable
Philadelphia.
experience.
It's an interesting experience.
But the point is that, is there any metric on the outstanding citations?
That's what I'm afraid to find out, Mr. Chairman.
No, but it can be, we can get that, and I think it should be an important part of our discussion as we go forward. I think so.
Okay. All right. Well, thank you to all members of the panel for coming up
Appreciate
today
it.
and sharing your time with us. We do appreciate it. We're going to move right to the criminal defense attorneys. I think we have David Clark and Doug Rohan. If you want to approach, we'd really appreciate it. And are you guys singular or working in tandem here?
Judge, I'm here on behalf of GACTL, the Georgia Association of Criminal Defense Lawyers, and I'm not working with Mr. Rohan. I welcome his participation.
If any, it probably offends everybody in this room for you to call me judge. Believe me, because I am no judge.
Of course I have. There were so many in the room. Mr. Chairman, I apologize.
That's all right. That's fine.
And I apologize.
Just for the opportunity for a lighter moment. It's good. Okay.
I'm sorry I left my coat in the kitchen this morning
That's
with
all
my
right.
brain. So
That's all right. Okay.
no
Why don't we
disrespect
just go ahead and introduce yourself again,
Judge,
Dave.
I'm David Clark. It's an honor to be here to a judge. Mr. Chairman, I apologize once again. I'm David Clark. I've been a traffic lawyer for 22 years. I'm a retired magistrate judge from Gwinnett County. I'm married to a former prosecutor. I've kind of seen most of the sides of this issue. I'm here on behalf of GACTL in place of Sandy Michaels, who is out of state representing a Georgia citizen this morning. GACTL, the Georgia Association of Criminal Defense Lawyers, is in favor of Title 40 reform and wishes to be part of the conversation. We support broad decriminalization of minor traffic offenses plus other petty offenses that are not traffic related. We submitted a memo to y'all, and we would be delighted if you would consider the points in our memo that we submitted. A lot of the points we made were made by Stephanie. The judges and solicitors, we agree with some of their points. We'd like the state to consider going further. What hasn't been mentioned is the potential revenue positive effect of reform for the state in general, plus the cost savings on many levels. We're not talking just about jury trials, but anybody who's accused of a misdemeanor traffic offense, the case has to be processed from the time of writing the citation. There is officer time in court involved. There are clerks. There are solicitors. Before a jury trial is even considered, there's expenses that are related. We envision an internet-based system of paying fines on these tickets. Many municipalities already have internet-based systems where you can just go online and pay your fine. I know Johns Creek and Suwanee have very good systems. Many municipalities have done this. I want to mention that we believe this legislation will ultimately be law enforcement neutral. We've looked at the search and seizure issues. We don't believe that they're an issue. We're happy to discuss that further during the course of the consideration of this measure. Basically, under a decriminalization, or what we like to call citation-based enforcement of criminal laws, an officer would still write a ticket just like he does right now. The ticket might actually be printed on an envelope instead of a little piece of yellow paper so that the person can mail in the fine if they don't have a computer, but basically pay the fine online. One has to remember, as important as traffic offenses are, there are other ways that traffic behavior is enforced. The DDS has a point system for moving violations where in Georgia right now, and it will be in the future, if you get a certain number of points, you get your license suspended if you're a bad driver. Insurance rates go up. This is a non-governmental way of regulating traffic behavior. Your average driver thinks about this when they get a ticket or when they're driving down the road. One of the advantages of citation-based enforcement through an internet collection method would be the lack of plea bargaining. I think it would give the point system more teeth, because you're supposed to get 3 points for a traffic ticket over 14 miles per hour, but as the member pointed out, a lot of times if you go to court, they just don't want to deal with your case. They'll reduce it down under 14 so that they can just get their fine money and send you home. That wouldn't exist in an internet-based system. It might give our point system more teeth and actually increase the effectiveness of traffic regulations. To two more things to consider in the public interest is uniformity, as the member pointed out. Right now, depending on where you are in Georgia, you're going to get treated differently if you get a window tint violation. Let's say you're in McRae coming home from a successful Georgia victory over Florida, and you're on your way home and you get a window tint violation in McRae. Well, if it was internet-based, you'd pay the same fine online at home in Roswell or in Rome, and you wouldn't have to leave home. If you wanted to contest the ticket, you could potentially do it on video conference, since this is civil. Civil Practice Act would not apply. It didn't apply in magistrate court when I was there. It does. You could use OSA judges, the Office of State Administrative Hearing judges. You could bid out the judging to lawyers or existing judges. The cost savings are exciting to think about for the state. And to the consumer, to the citizen who has offended, they can pay their fine online. They will know that their license will be suspended. If they don't pay the fine, that's one way to collect it, is to impose license suspension. To most of my clients who faced criminal sanctions, these are offenses where you're not going to go to jail anyway. Nobody goes to jail right now over these offenses. So taking the jail part away doesn't change anything. They're concerned not so much about the money, but losing their license. So the DDS has a system of points, and we could impose a license suspension for failure to pay this fine that I believe would be just as effective as criminal or civil contempt is also available as a remedy, and that does allow for 20 days in jail. The possibilities are worth discussing and worth debating in the future in this topic. I believe that those problems can be solved, though. We do, I believe, need to go to decriminalization, because unless you take away the jail time, the Constitution does require a jury trial and an appointed lawyer. If you want to not appoint these folks lawyers for a speeding ticket or a cracked windshield, we need to make it a civil offense and no jail time so that we can do that. Again, these people aren't going to jail for this now anyway. They're all getting a fine. All we're eliminating is expenses for the state, not the end result. So I believe the effective enforcement and keeping people honest and keeping them good drivers will not change. The other thing to consider that nobody's brought up yet is privacy. If you're arrested right now and you go to jail in Gwinnett County, your book-in photo goes online almost immediately, and there are these online sites that collect people's book-in photos and make them public and make fun of them. You look at a scenario where a young, over 17, the juvenile court cuts off at 17. If you're 17 or above, and you make a mistake, and you're a good kid, you've got a scholarship, you're going to college, whatever, you make a mistake, get caught with marijuana, get caught with alcohol, and you get arrested, your book-in photo, which is normally not a very complimentary photo, goes online and is, there are services that collect them and send it to you. This is, your neighbor got arrested, and it tells you. This is a concern of many of our clients. If it was civil, there'd be no arrest, no book-in photo. Privacy of Georgia citizens is protected to a greater extent. This is a real concern for people who, my practice is basically people who are just stupid and make a mistake and they'll never do it again. And then there's folks who are recidivists and deserve to go to jail. These folks whose child, they've invested in their child's education, they're going to Georgia or unfortunately maybe Georgia Tech. They don't want their child's career ruined or political possibilities ruined by some mistake they made when they were 17. It's already on the internet, and the internet never goes away. I don't care if they get dismissed or expunged. The internet's forever. So that is a concern to think about. And of course the uniformity and the convenience. Now, it shouldn't be really convenient to get a traffic ticket. Traffic ticket's a serious thing. But we have to make some hard choices right now, and the revenue available to the state by doing this is exciting, and it's a hard decision. We don't want to imply that traffic is not important, but we're talking about offenses, again, that result in a fine anyway, and we're just increasing the efficiency of enforcing the law. Citation-based enforcement is not an endorsement of driving poorly or a young person having alcohol or cigarettes or whatever, but it's taking certain offenses and enforcing them more efficiently. Mr. Chairman and members, it's been an honor, and certainly we'd like to be a part of the conversation as the consideration of this measure progresses. And thank you very much.
Thank you, Judge Clark. I appreciate that. And other questions for Mr. Clark? Well, seeing none, I appreciate your twice getting an endorsement of the dogs into your conversation, very surreptitiously, but very, very nice, and I appreciate that. Thank you for the ideas on privacy and some of these other thoughts that you brought forward that we may not have thought about.
Thank you, Mr. Chairman.
Okay, thank you, sir. Okay, Doug Rowan. Oh, I'm sorry. Okay, all right, that's fine. Well, we can move right along. Ruzi Patel from the Municipal Association.
Thank you, Chairman Rice and Chairman Golick. I think one of the benefits of coming up after that murderer's row of judges and prosecutors earlier is that I can cut down what I said and hopefully get everyone back on schedule. GMA and our member cities, mayors, council members have many of the same concerns that were expressed by the judges and prosecutors that were expressed earlier. So what I'd like to do is explain how those concerns translated into a new GMA policy this year. And that GMA policy was adopted by our Legislative Policy Council, which is comprised of mayors and council members. And that new policy reads as follows. GMA opposes attempts towards decriminalization of misdemeanor offenses, including traffic offenses, unless such legislation does not threaten to compromise public safety and remains revenue neutral to the operations of municipal court and municipal government. So that policy is now part of our general overall policies for the upcoming legislative session. We've had many conversations with various stakeholders and have worked with AOC, and everyone's been great to work with, and we hope to continue to work with everyone on these issues. And we understand that there needs to be some sort of wiggle room in negotiations, and we're glad to do so. And I think there's a lot of great ideas that have been presented today, and hopefully that can lead to some significant progress in the future. Our policy in general has two parts, really. One's related to public safety, and the other is related to the ugly head in the room, which is revenue and fines. And no one likes talking about it, but our policy does cover both. Related to decriminalization and parts of public safety, I think one of the things that needs to be taken to look at basically is decriminalization has the ability, the penalties related to decriminalization associated with minor traffic offenses are at least partially responsible for people taking crime seriously, for following the law. Basically, the penalties that are in existence are there because they do deter people from violating the law. One good example would be the Move Over law, which was passed in 2003. I think everyone here would agree that that law raised awareness for people to take heed of moving over and keeping our public safety personnel safe. It is important to keep that in mind, whatever changes are made in the future, that laws like that, with the penalties associated with them, it's the penalties along with the awareness. It's not one or the other. It's the combination of both that keep people obeying the law and keep public safety safe, keep citizens safe for other minor traffic violations. So if drivers begin to feel like any penalty is worth the risk, if a penalty is too small, if drivers feel that it's worth the risk, or if they feel that the penalty has little likelihood of being enforced, then we're going to have a public safety problem. I think that people need to be aware of that. And now to the uglier part is fine revenue. Municipal courts pay for indigent defense costs themselves. The training for municipal court judges and municipal court clerks is paid for by the municipal government. So this is a significant issue for municipal government and municipal courts, because public safety, when it comes to minor traffic offenses, our courts, our police officers, our police chiefs, they're the ones that are enforcing a lot of these laws throughout the state. But it's also important with the fine revenue, because this is not an insignificant issue, I should say. Year in and year out, municipal courts collect a large percentage of the fine revenue throughout the state. I think if you look at the statistics, on the AOC website, municipal courts tend to collect somewhere in the low 40% range of the fine revenue collected in the state. And that's not a small amount. Sometimes it's close to $200 million. So we're talking big numbers here. Of the fines collected, it is interesting to note that of that percentage collected by the municipal courts, the part that goes back to city or county general funds is lower than, or for the city part itself is actually a lower percentage than the part that goes to the county general fund, and that's because counties have more varied courts, but it is interesting to note that these fines collected that affect municipal courts don't just go to municipal courts. They go all over the place. They go for your victims assistance funds. They go for your retirement funds. They go to other courts. So we have two issues. We have this massive public safety issue, and we have a revenue issue. I think working with a lot of folks, Mike Kikaro at AOC has been wonderful to work with on this issue, and the governor's office has been great to work with as well. I think we can find compromises and solutions, and I think the judges and prosecutors earlier stated many of the concerns and many possible solutions that can be worked with. So with that, I'd like to yield the well, I guess.
So, that's fine. Any questions? I got any questions? Well, thank you so much. I appreciate Mr. Patel, you coming up and explain the position of Municipal Association. Appreciate your work.
Maybe we could franchise speed traps.
I think we ought to turn the microphone off for that, but that's fine. Well, we've got another presentation, and I'd like to. We are behind a little bit, but I'd really like to hold us here for a few minutes while Greg Dozier and Mike Mitchell and Jennifer Ammons from the Department of Driver Services come up. I've asked them to come up today to help us understand kind of where we are and some of the things that the state administers with regard to driver services and other things that are different than what we've discussed so far this morning. We've been really keyed on that one issue of decriminalization, and but we need to broaden this because the Code Section 40 does deal with a number of things that have to do with the department's services that they provide. So, Mr. Commissioner, we're here to welcome you today. We know that there's a presentation in the folder that you're going to follow through on, and if members of the committee want to review that as you go through, that's fine. And you can direct the comments of your two associates as you see fit.
Mr. Chairman, I'm just going to kick it off and thank you for the opportunity. Obviously, you started this meeting talking about focusing on the enhanced safety of our drivers on our road, and obviously that's what the employees at Driver Services are really focused on. It's something we take pride in as far as making sure that we do our part in that area. There were several topics that you and I had discussed, and we do have a presentation on it, and I'm going to ask Jennifer Ammons and Mike Mitchell to present on those, but obviously we would welcome to answer any questions that you or the committee may have, and will obviously help as this committee moves forward on any topic that you need. So if appropriate at this point, I turn it over to Ms. Ammons to begin that presentation.
Well, Jennifer, it's good to see you again. And
morning, Mr. Chairman.
Jennifer is the counsel for the Department of Driver Services, and I appreciate you coming today. Why don't you go ahead?
Well, thank you. In the interest of time and speed, I probably won't cover every single nuance of the material, but just want to give you some background on Georgia's graduated licensing process.
Excuse me, just a second. I forgot to tell the committee member. In your folder, I've asked for a couple of things to be placed, and one of them is the, whatever I did with it. Here it is. It's the transportation series from NCSL that does state-by-state comparisons on a number of the issues that will be brought up in this discussion today. And so you can get a feel for how Georgia looks and Georgia ranks with regard to other states and some of the issues that have been brought up, even including the criminal offenses we've discussed this morning in terms of penalties and things like that. It's a great article. Thank you, Jennifer. Go ahead.
Georgia's graduated driver's licensing process began as part of the Teenage and Adult Driver Responsibility Act. It's actually been in place for approximately 15 years. A teen in Georgia starts at the Department of Driver Services applying for a learner's permit at age 15. And to obtain a learner's permit, you have to successfully complete the written test, at which point you're authorized to drive with another licensed driver in the vehicle with you. That person has to be at least 21 years old. Once the child has had the learner's permit for at least 1 year and has not incurred any of the a conviction for any of the offenses that would trigger a suspension under the TADRA provisions, then that child is eligible to come in and take the road test, either with us or with a licensed driving school. You may recall Joshua's Law was enacted about 6 years ago and shifted the age at which a child can take the road test. If they've completed driver's education from age 16, it would stay there, but if they haven't completed driver's education, then they have to wait until they're age 17. The kids who successfully pass the road test or issued a Class D driver's license is referred to as a provisional driver's license, and it carries limitations on the scope of their driving privilege. There is a curfew. They're not allowed to drive past midnight or earlier than 6 a.m. There are limitations on the number of passengers that they can carry, and there are limitations on who they can carry. Over the course of the year that they would hold a Class D license, they're only allowed to carry a certain number of people who are teens themselves, because there's definitely been a correlation in the statistical information and in crashes and injuries when teens are driving with other young people in the vehicle, and they're required to only be driving with people who are members of their immediate family. And you may recall that in the last year we've actually asked the General Assembly to define what an immediate family member is for that purpose. Once a child has had that Class D license for at least a year, they're ready to transition into a Class C license, which would be the general non-commercial license that any adult would be issued. The Class C license has no time limitations as far as a curfew. It has no passenger limitations. It's that license that lets you drive your Honda Accord, your Chevy Malibu, what have you. Over the years, there has been analytical research done, both in Georgia and nationwide, definitely showing the benefits of our graduated driver's license system: fewer crashes, fewer injuries, fewer teens being killed. And DDS is very proud of the role that we play in keeping our teen drivers safe. With regard to the teen drivers and the consequences that they face, you will probably be familiar with the language in TADRA that applies license suspensions for certain offenses. They face suspensions if they incur 4 or more points in a 12-month period for a child who's under age 18. Anyone who's under age 21 who's convicted of a 4-point offense is subject to a 6 or 12-month license suspension. They also face enhanced penalties with regard to a DUI offense or some of the other mandatory suspension offenses. There's also the texting law that applies to those kids. They're not allowed to text or use a cell phone while operating a motor vehicle. And as mentioned previously, they would be subject to a point if convicted of that offense. I'm trying to cover a lot of really fast.
You're doing fine.
With regard to our adult drivers, we have a multitude of different classes that we offer to them, both commercially and non-commercially. Your commercial classes of license would be A, B, and C. A is your big tractor trailers. B is more of your panel trucks. C would be really any kind of smaller vehicle where they're potentially carrying some sort of hazardous materials. B would also be the class of license that's issued for like your school bus drivers and the big buses that you see on the highway taking groups of people on the road. We offer non-commercial licenses for larger vehicles that are not considered commercial vehicles under federal law or state law. Those are typically offered for folks who work in agricultural industries and for our first responders operating firefighter apparatus and things like that. Class M licenses are for your motorcycle operators. We offer our own motorcycle safety course, which is found in a separate chapter of Title 40. And we're happy to answer questions about that as well. And we have instructional permits for our Class M licenses. It's all of the licenses that we've discussed so far. The driver would begin with an instructional permit in a written test and then develop those driving skills before actually being turned loose on the road to travel by themselves. And that's the first half of Chapter 5 of Title 40 in about 2 minutes.
I'm going to stop and take a question
Yes, sir.
right now from Chairman Coley.
Thank you, Mr. Chairman. Appreciate the presentation in the packet. It's good, consolidated information that we need at various times, so it's good to have that one resource. I want to direct your attention to the subject of teen driving, and specifically the provision regarding teen drivers and the number of other teens in the car at the same time. I think this is addressed on page 8 of your handout.
It is.
On the first bullet, it says, after the first and second 6-month period, only 3 passengers. I think what you mean is it 3 or... clarify, if you would, what is the limitation on, you got a teen driver, how many other teens can be in the car with that teen driver as per Georgia law right now?
The maximum would be 3.
It's the maximum in the entire car.
Yeah. Well,
So,
3 plus the driver.
3 plus the driver.
Yes.
Okay, so you got a maximum of 4 teens in the one, including the driver.
Correct.
Okay. I have, and you may have seen the same thing. I'm sure you have seen the same things as I have. I have seen empirical data, quantitative and quality data from several sources, including yesterday from the Insurance Institute for Highway Safety. And for those who don't know, the Insurance Institute for Highway Safety is funded by the insurance industry, which has a financial interest in the well-being of people's children, their teenagers, from a claims perspective, and of course from a collision perspective on the vehicle itself. And so it's taken pretty seriously. I think it's universally, maybe grudgingly accepted by some in government as being much more rigorous in terms of its crash testing than the National Highway Transportation Safety Administration. It's not a put down of NHTSA, but it's perhaps a little more rigorous testing from private industry and IHS, which is the reason why all the car companies brag about their IHS rating in their television commercials, which we see about 50 times a day. That being said, what I have seen from the IHS is that there is a noticeable empirical decrease, empirically proven decrease in the number of collisions and fatal crashes when you decrease the number of total teenagers in the car. Do you agree with that statement?
I definitely have seen the same sort of results from the research that I've seen.
Thank you. Does DDS have, and if you can't answer this now, I understand, because I haven't warned you about the question, but does DDS have a reflexive opposition as of this second to the possibility of the General Assembly considering, if not passing, legislation to reduce, in light of that empirical data, which will save lives, empirically proven? Do you all have any position, reflexively positive or negative right now, about any legislation that would be put in and considered, from Chairman Rice obviously, to reduce the number of teenagers that may be in the car while a teenage driver is driving? A simple yes or no will be fine.
Mr. Chairman, she was sliding it to me, so I figured I might as well go ahead and grab it. Obviously, at this point, we don't have anything that goes against safety. We'd have to obviously look and see what that legislation looks at. Sure. And discuss it with others. But I also want to make sure that we're clear, not saying that what we have today is perfect, so sure. Don't mishear what I'm stating here. We have 2 levels on.
And if it's imperfect, it's not your fault. Right. It's our fault.
We do have 2 levels today, just so as we look at this and as we move forward, I believe, Jennifer, you correct me if I'm wrong, the first 6 months you could only have 1 other person besides a family member in your car. After that, then you can have the 3 as you guys were discussing.
Okay,
so
during
2 levels today.
Right. So then the second 6-month period
exactly.
after the provisional, after the issuance of the provisional license.
Yes, Mr. Chairman.
Okay.
And obviously that's been in place for quite some time now, so it probably is time to relook at that. Georgia's been noted, and Jennifer was mentioning NHTSA came and did a study on our TADRA laws, and very proud that we reduced over 36.7% reduction in fatalities as tied to the TADRA laws that were passed, I believe, beginning back in '97. Is that right, Jennifer? So we have done a few things since '97 to enhance those TADRA laws. But as we continue to look, there's always areas, as you've just pointed out, one that potentially can save lives.
I mean, you're
absolutely.
And I don't know what the magic was then, and others could speak to it. I can't speak to it because I wasn't on that committee then or now. I don't know what the magic is or was between the first 6 months and the second 6 months, but what I know is the thought of my now 11-year-old going to be 16-year-old boy in only 5 years with 3 of his teenage buddies in the car at the same time scares me to death. And so I'm wondering if we have the empirical data that demonstrates that lives will be saved, the number of collisions will go down, and the number of fatal crashes will go down. Not to be overly dramatic about it, but if you save a life, why would we not do that, especially if the empirical data exists?
There's definitely been a correlation in the cognitive ability for teens to assess dangerous situations, and I believe the research, I haven't read the study that you're talking about, but I believe in the other areas that I have seen that are talking about the cognitive ability of our younger drivers to assess the dangers in situations. And hopefully when you have a car full of adults and one of us are driving erratically, someone's going to say, hey, you need to stop. A carload of teens don't seem to assess it in that same way. They may actually see it as a thrill. And I believe that I have not seen the research you're talking about, but I would guess that that's part of that research that you see. So I think there is a correlation. I do think it's something that we would be happy to look at with you.
I haven't officially pitched the chairman about this yet, but I'm going to. But I want to give you a heads up as well that it's an issue that I'm very interested in and hope we can gather some good bipartisan support on it because the data's there. Thank you, Mr. Chairman.
You're welcome. Talking about data, for the committee members, in the Appendix E of this NCSL series, you'll find the teen driving restrictions by state. So I think we can refer to this and get an idea as to how we fare. It'd be interesting if the department would just take a look at that same information. This is from this NCSL transportation series done in February of this year. And just for example, it tells you Alabama, this is all teen driving restrictions, Alabama, no more than 1 passenger for teens. You know, you go down that, Arkansas, no more than 1 passenger, and so on and so forth. You can see pretty clearly, you know, what the other states are doing. What we don't know is the results of that in terms of how effective those laws are. So I'll just, for the committee's benefit, provide you that information. But there appear in this list a lot of no more than 1 passenger restrictions apply. Okay, we've got Mr. Powell. Other Mr. Powell.
A couple of questions, and good to see you, Greg. Since this whole discussion seemed to be all this morning based about money, seems to be the base of everything, I want to ask you a question specifically. I know that a lot of times we pass legislation out of with total disregard about the implementation of it. If this thing picks up legs and travels forward on decriminalizing all parts, some, none, or whatever, if that, to me, it's, you know, as a non-attorney, non-judge certainly, I've thought about that some of these things might be, if they're decriminalized, that basically could work in the same system when they send the record to DDS. Say somebody doesn't show up, if it's decriminalized, somebody doesn't show up to pay a fine for a windshield infraction or whatever it might be, whatever it's decided on. If they send that record to y'all, as they currently do right now under the criminal process, could y'all not suspend that license, or is that something that's workable in y'all's mind, that it could basically work the same way, that y'all would basically suspend the license, and that would be the stick for them to pay that civil fine?
Hard question to answer, obviously, as the committee works through it. And Jennifer, I'd ask you to kind of jump in here, and if I'm saying something inappropriately or incorrectly, correct me. But I believe that, you know, one of the things we've got to look through is there was testimony this morning of does a UTC, which DDS oversees, does it become an envelope? So we've got to watch as the committee continues to work of how the UTC evolves as far as depending on where you guys go with the current structure versus a line drawn in the sand and violations going below and above the line. I think obviously all of it's workable. It's just we got to make sure we understand how the UTC will look, what the expectations are from the General Assembly as you look at this when you pass, or if you should pass, lowering down some offenses that are non-moving to non-criminal offenses. Is there an expectation we still follow the same point system, things of that nature? And I know that there's been a lot of discussions around that, but we're still looking at it. Obviously, we're going to do the administrative side the best we can, and we believe we can work through whatever it may be. But we are curious as we go through this process of where do we go and what are you guys going to instruct us as far as the offenses, and is the current point system what we're going to continue with, or does it differ as you look at it? And I'm going out on areas I haven't studied. Chairman Golick obviously is more familiar and hands-on in that, and others in the room. And we're just saying that we're going to do our part on the administrative side. Jennifer, I'd ask if there's anything else that should be said on that topic.
The only thing that we would be looking for was language that either directs us to stop assessing points if a minor traffic violation becomes a civil infraction or some lesser sort of offense. And we would also point the committee members to the provisions of federal law that deal with our commercial drivers, and we need to make sure that whatever direction you decide to go in, we are not creating any sort of jeopardy with Georgia remaining compliant with the regulations of the Federal Motor Carrier Safety Administration with regard to commercial driver's licenses. There are some offenses that are deemed serious offenses by the FMCSA if a commercial driver is convicted of them. And it's not something, following too closely, rear-ending somebody essentially would be a great example of that. That's the sort of thing where DDS is going to have to continue to collect that information, and so it will be vital for whatever product comes out of these meetings is cognizant of the need for our need to continue to collect information about some things. Whether you decide that some moving violations need to not show up on driving records anymore, there are some things where we're going to have to remind you we have to have that data. Like the envelopes that were mentioned earlier, there is data about those sorts of tickets that we have to be able to collect for NHTSA and for the FMCSA. And really, I think that's what the commissioner is speaking to, is the administrative side of what we're going to have to do to make sure that Georgia stays compliant with the requirements under federal law. But we're here, as he said, to administer whatever is enacted.
Then, well, let me ask you, is there any way that y'all could computer generate a list of offenses without the specific definitions in the whole code section, so that it might be simply that we could look at them? Because quite frankly, some of these things maybe just need to be abolished altogether if they're so insignificant that all they are is just a rationale to PO the public out there and give them a reason to be stopped.
We definitely already have a list of offenses that are reportable to DDS that will appear on a driving record that I could make available to you today. That's quite easy.
Yeah.
And while you're doing that, I think it would be interesting to know from the record that the DDS collects some metric information on those too. If you know how many of these offenses have been committed over a period of time, a year, that would be interesting to know.
We will have some of that readily accessible. Some of the more minor things where it's stop signs, it would require us to actually query the system to get that sort of data.
I see. I think you give us what you got. Spend the rest of the time servicing those good people looking for new driver's licenses out there, which you've done a great job with. Chairman Golick.
Thank you, Mr. Chairman. Just a very quick follow-up to Mr. Powell's point, Representative Powell's point. If we were to get to it, and I'm not saying that we will, but if hypothetically we were going to reclassify some offenses, and within that reclassification we were to put in, if there were a non-compliance, a license suspension, my assumption is that within that legislation it would be prudent for purposes of the administrative challenge that it may present that we would do well and be prudent to potentially include the ability to promulgate via rule and reg, so that we don't have the law of unintended consequences, pop up in terms of a noncompliance with a national rule or regulation or federal law. I assume that would be the safest route. If we were to go to reclassification and then with a noncompliance, a license suspension, well, how is that going to happen? What are the administrative dynamics of that? Do that through rule and reg and allow and provide for it in the underlying statute. Does that make sense? And that's generally the way it works anyway, right?
Yes.
Okay. Okay.
Thank you. We're going to move ahead. I've asked Mike to comment on the driver training program because there was other testimony to come this afternoon on that whole issue.
Thank you, Mr. Chairman. I promise to be brief as well, but this is an area that sometimes gets me excited and I can get off on a tangent. So
Get excited. We need some excitement.
Got a lot of good information for you here. What I would like to do is just give you a very quick breakdown of the driver safety programs that we regulate, that being driver training, DUI risk reduction, and driver improvement. And a lot of it gets confused from time to time, and some people don't understand the differences between the programs. So hopefully I can clarify that and provide you some beneficial information. As Jennifer alluded to, driver training is statutorily required for 16-year-olds here in the state of Georgia in order for them to get their Class D provisional driver's license. Those teens that do not complete driver training, they're not going to be eligible for their license until they reach the age of 17. Georgia's driver training program consists of two components. There is a theoretical component, which is 30 hours of classroom instruction or 30 hours of online instruction. And there is a practical component, which is either 6 hours of behind-the-wheel training with a licensed instructor or 40 hours of parent talk. Parent talk is an accessible and affordable means by which parents can teach their children the behind-the-wheel practical training. It's absolutely free of charge. The parent-teen guide can either be obtained online at the DDS website or can be obtained at one of our customer service centers around the state. Presently, there are 291 licensed driver training programs here in the state of Georgia. 148 of those are privately owned and operated, and 143 are offered by high schools. There are three types of driver training programs here in Georgia. There is the full 30 and 6 program, which is the traditional driver training program that most people think of. That's the 30 hours of classroom instruction in a brick and mortar school, coupled with 6 hours of behind-the-wheel training with a licensed instructor. Those programs, by far the most popular here in the state of Georgia. There are 239 30 and 6 programs in Georgia today. The second type of driver training program is the limited driver training program. Those are the programs that offer less than the 30 and 6. Those could be a 30-hour classroom-only program. That could also be the 30-hour online program, or it could be programs that just offer 6 hours of behind the wheel. And in the handouts that I gave you, I provided a breakdown of the number of those programs that are here in the state of Georgia. There's a third type, which is not very common. In fact, we don't have any of these programs right now in the state of Georgia, and that is a temporary driver training program. And these are programs that, for lack of a better way to explain it, sort of travel throughout the state offering driver training, but they do not have a fixed permanent location. Also like to note that there are a number of colleges and universities here in the state of Georgia that offer driver training. Those programs, however, are statutorily exempt from DDS regulatory oversight. 22 of those programs, however, do participate in the DDS online certificate recording application, so they do report their student information to us, although they're not required to do so. Also would like to point out that there are 28 driver training programs here in the state of Georgia presently that offer third-party testing. And it's important to note that this is non-commercial third-party testing. If a teenager goes through a 30 and 6 program at a brick-and-mortar location, and that program also does third-party testing, the teenager can go ahead and do the behind-the-wheel skills test there at that school without having to take the skills test at the Customer Service Center at DDS. And the previous fiscal year, FY 2012, there were about close to 4,500 third-party skills tests that were performed by driver training schools here in the state. Driver training course costs are competitive, meaning that they are not regulated. They range from approximately $500 for a full 30 and 6 class with a third-party skills test to $30 for a 30-hour online course. And there are some incentives for parents and children that go through driver's education. Parents or guardians are entitled to Georgia income tax credit of up to $150 if their child completes a private driver training school that is licensed by the DDS. And also statute requires insurance companies to provide a 10% discount in insurance premiums if a teen completes a 30 and 6 program. The number of Class D issuances each year since 2007 has remained relatively stable, although it has increased some, and it ranges between 45 and 50,000 Class D issuances each year to 16-year-olds, and these are the 16-year-olds that would have to go through the driver's ed. And the number of Class D issuances to 17-year-old teens has also remained relatively stable since implementation of Joshua's Law, but it is quite less than the number of kids getting the Class D at age 16. Also provided a handout that just breaks down the driver training demand based on the Class D issuances. You can definitely see that the most popular form of driver's education among teens is the 30-hour class and the parent-teen guide. The next program that I want to talk about briefly is the DUI risk reduction program here in the state. It too is comprised of two components. There is an assessment component, which is a 130-question screening instrument that customers take when they come in. It measures the extent of the individual's drug and alcohol use. The results of the assessment are actually incorporated into the intervention component. And the intervention component is the actual 20-hour class that the student or offender takes in order to get their certificate of completion. A couple of terms that you will hear within the context of DUI risk reduction is clinical evaluations and substance abuse treatment. And just like to note that those services are regulated by the Department of Behavioral Health and Developmental Disabilities. Fees for the assessment intervention component are set by statute. The fee for the assessment component is $82, and the fee for the intervention component is $190. So schools cannot charge any more or any less for those two components. And there is also a workbook fee. It's $20, and that is a workbook that the student has to purchase in order to take the class. Presently here in the state of Georgia, there are 290 licensed DUI risk reduction programs and 659 licensed risk reduction instructors. And last but certainly not least is Georgia's Driver Improvement Program. It's commonly referred to as defensive driving. It consists of 6 hours of classroom instruction, and programs can choose from 6 different curricula that have been approved by the Department of Driver Services. It's the responsibility of each curriculum provider to train the instructor on how to deliver the material. Like DUI risk reduction, the fee for driver improvement is set by statute. It's $75, no more, no less. if the course is taken for points reduction, reinstatement, or 0 points order. Programs do have some flexibility in what they can charge if the course is being taken for insurance reduction. So what you will see a lot of driver improvement programs do is offer that insurance reduction course much less than the $75 just to, for a competitive advantage. 216 presently licensed driver improvement programs here in the state, 419 licensed driver improvement instructors. Mr. Chairman, thank you so much.
Questions for Michael? Any questions to me? I got a question or comment as you go back to page 18, which is your graph, your bar graph of driver training demand. Is there any difference? Has that been correlated to accident rates in terms of driving, as parent taught versus school taught, or whatever it might be? The other options.
It has not. It's something that has been discussed within the context of the Driver's Ed Commission. That would take some coordination among a couple of different agencies, ourselves, Department of Transportation, that maintains the traffic accident reports. And I would think that it would probably require somebody with the skill set on our staff to actually to look at that, epidemiologists.
Another question that's occasioned by this: when you get the opportunity for the driver improvement course, which does help in point reduction, do you just let me ask you how many people actually attend that for point reduction? I mean, obviously the revocations are. I mean, I don't know if they're stable or not, but are we seeing a lot more people taking those courses for point reduction right now?
It's remained relatively stable. We could certainly pull those exact numbers for you. We like to look at the overall number of people that are taking the course, and we look at a couple of different things when we look at that. We look at the number of certificates that we provide to the school, and I can tell you overall the number of people that are going through the driver improvement program, reinstatement points reduction, ranges between 45,000 and 50,000 people a year, and that's pretty consistent with what we're seeing with risk reduction. It's about the same number of people that are going through both programs each year.
Okay. There was another question I was just thinking about, the driving without a license. The number of circumstances, apparently, from what I can read in all the literature, the driving without a license and therefore without insurance is endemic across the country. Is this? I mean, where do we find ourselves in this state? Can you tell us a little bit about that?
Driving without a license has been criminal law for decades. There has been some expansion of the consequences over about the last 5 years. In 2008 and 2009, the General Assembly revisited 40-5-20, which is the code section that deals with driving without a license. Candidly, I think a lot of that effort was build up to House Bill 87 and things related to immigration law. Now when a motorist is stopped for a violation of 40-5-20 and the officer determines that he or she is unlicensed, that's someone that's going to be taken to the jail and fingerprinted. And the minimum penalty that person faces is identical to that for driving with a suspended license, which is a minimum 2-day sentence and a minimum $500 fine. So from DDS's perspective, and we really are not invested in the criminal side of it, we have definitely seen an enhancement in the consequence for driving without a valid license. Prior to the action that was taken in 2008 and 2009, that offense was not even reportable to DDS, so it would not have appeared on a driving record. Now a fourth offense in 5 years is a felony. I don't recall having seen any of those since the time that the law has been enacted. I have dealt anecdotally with prosecutors and judges who have had those cases pending, but it's certainly not something where we've seen a flood of convictions for the felony offense. We're definitely seeing the driving without a valid license appearing on driving records.
Mr. Chairman, if I could add to it, also looking at it not only from the penalty side, but looking at it on the philosophical side. There has been a little bit of a movement nationwide to look at, should we be suspending people versus keeping them licensed but under more supervision? And that's a very, I don't know where the state of Georgia would fall in that area, because it's a very costly endeavor, and it hasn't been proven to show that it has results yet. But I would share with you that that's something that the community, when I meet with my other counterparts across the nation, that's the question that we're getting asked as motor vehicle administrators is, should you be working toward not suspending folks because once they learn they can drive without a license, they continue to do it? So it's a balancing act, and it's one that I think Georgia's done a great job on making sure that once someone's convicted of that, we have a good penalty. But how do you address the nationwide issue? And no one can give you a good number. Everybody wants to know, and I think you and I have talked, what's the supposed number of folks that are out there driving? And you hear different research people say as many as 1 in 10 are driving without a license, and then you hear other numbers much lower than that. Right now, I think the nation as a whole is struggling with how do you address this epidemic, if you want to call it that. But I do think Georgia's in a very good position of once we catch somebody doing that, we do have the penalties in place to assess it. But trying to create a culture of people who do not do it is where we really do need to look in on that.
In some of the literature I've read, there have been other alternatives, such as North Carolina, and we do too. But I think North Carolina mandates the pickup of the license tag. We have that option in our law, but it's not followed, I think, from the standpoint of costs and other reasons. Just an officer out there picking up a license is probably not, or a tag is probably not the best use of their time and consideration. Other ideas have been zebra striping that are only observable to on the tag. That's only observable to police officers that they have been driving without a license. That type of thing. You have any comment on that as alternatives?
I think we just need to look with you in that. I really, at this point, I wasn't familiar with the zebra striping until you just brought it up. So I need to educate myself on that a little more as well as we look into this. So my apologies for not having a good answer on that today, but we will continue to research that area.
Chairman Golick has a question. Okay. All right. Any other questions of the Commissioner and the staff? Well, we want to thank you. I know these have been interesting times for you in the driver services area. You managed to make the news several times, but recovered quickly. And I think your times to get and by the way, I just want to comment that we did pass the law that enabled Real ID to become something we had to follow from a federal standpoint, and you guys have had felt the brunt of that in terms of the identification requirements, and there is some startup time to address that, I know, but my understanding is those times are coming down.
Yes, sir. We thank you for that recognition, and on the cusp of 9/11, we're just real proud of the state for being on the forefront of doing our part to protect our homeland, so thank you.
With that, we appreciate you coming today. Thank you so much. Let's see, it's 12:35. Judge Clayton, are you here?
Yeah.
Did you want to comment on the DUI law? I mean, we got you scheduled here before lunch. We're going to break for lunch right after you. So I don't know what you prefer, to come back or you want to go now. I think you got a 15-minute presentation. Is that what it says? Let's go ahead and do it.
On my way up there, I'll say that I didn't know I was coming here until six calendar days ago. So I did do a paper for y'all, but it's very short. So anything that y'all want more than that, please just let me know. Do all of you know what a DUI court is? I hope. an accountability court. So
Yeah.
our most important message to you is that we have to have at least 24 months to work with in order for DUI courts to work. In many cases, we're even giving 36 months. And the way we do that is we stack. We run consecutive sentences based on the DUI and the probable cause offenses that brought about the stop. If we can't do that, then we can't run DUI court. Just as to DUIs in general, you have a situation where we could possibly change, and I'm not following this paper exactly, but you could possibly change some of those offenses in their nature by being committed while in the commission of a DUI. For instance, improper lane change while in the commission of a DUI would be a different offense than improper lane change. Okay? It then begs the question of, well, what happens if that happens, the person gets arrested, they take them for a blood test, and 3 months down the road the results come back and it's negative. Does that improper lane change still result in being a misdemeanor? I mean, that's just something you have to look at when you're restructuring the law. Or does it then drop down below the line that Judge Darden was talking about? We have sort of the consensus. I'm on the DUI court committee of the Council of State Court Judges. I'm not the chair. Nobody else was available but me to come. I am a past president of the Council of State Court Judges, as Judge Darden, there he is, will eagerly point out to you, I am the most senior judge on a 12-judge court. Okay, so I have a lot of varied experience. Before I was a judge, starting almost 20 years ago, for 12 years before those 20, I was a criminal defense attorney for 7 and a prosecutor for 5. Okay, so I handled all kinds of criminal during all of that, and I can tell you that it's not easy to change part of something. I'm glad that y'all are seeing this as a big picture rather than one little part and another little part. I can tell you that a defendant, for instance, in something that was just said about a fourth driving on a suspended license becomes a felony. Guys, if they'll drive on a suspended license the first, second, and third time, they're not going to say, you know what, this fourth time is going to be a felony, and I don't think I'm going to drive. It just doesn't happen that way. Those people do not think the same way that we think. We, the first time that happened to us, would be rushing down to the DDS and saying, oh my gosh, what do you mean I forgot to pay a fine? I am so sorry. Let me get that straightened out. Okay? Those people are different people, and that's a similar thing to alcoholics and addicts. They simply think differently because their mind is wired differently because of the way they react to alcohol and drugs. And that's why we have to have our 24 to 36 months. So one suggestion is that we make it a different offense. Another suggestion is that we create a new misdemeanor class. A second offense might be a misdemeanor of high and aggravated nature with a maximum punishment of 24 months. And the third offense might be with a maximum punishment of 36 months. We still, though, would have the problem of what if it was their first offense within 10 years, but it's their 5th offense lifetime. If we can't stack those other offenses as consecutive sentences, then we would only have the basic 12 months, and we can't do it in 12 months. We do have, in fact, if you're wondering, we have a lot of people that come in front of us who have had only one or two recently, but back a long time ago, they had several. And many of those people are people who have just not been caught during that period of time, and they need treatment. It's not that they just sort of messed up a couple of times lately or one time lately. They really have all this time they've been doing it but not caught. The reason that these courts are so important is that is what works. You put a DUI offender in jail, let's say under the present system, they got 2 probable cause things, I put them in jail for 36 months. They're going to get out in 18. And the first place they're going to go is the liquor store. And the second place they're going to go is to find where their car's been in storage. And they're going to start driving. That's just what happens. This is the thing that is the most effective way, and we've got to do whatever's necessary to give us the amount of time. I will say, I heard something earlier, someone earlier say that the goal may be to get these minor traffic cases out of state courts. That's not true. Where we have no problem having them in state court. I will say that based on my experience, some of the other things, actually, Gary Jackson's suggestion about the collection is a totally new thing to me, but, and he talked about the logistics of it and everything, but one thing was said earlier about making, say, a 4th offense lane violation is a felony. Well, the police officer who's writing the ticket out on the road is probably not going to have the time and maybe not even the ability at that point in time to know whether it's 1st, 2nd, 3rd, or 4th. That we, in the past in Cobb County, and we did it this way during the time that I've been there, and we gave up on it because it was too difficult. It took too much in the way of manpower and hours, and that was, we used to, when a minor traffic case came in, they checked every one of them for their record, and then they based the TVB fine on 1st, 2nd, 3rd, or 4th. That used to be the way we structured our TVB fines. Are all of you familiar with TVB? I hope. If not, let us know and we'll tell you. But that was how we structured our TVB fines. That meant that somebody had to check every single one of those citations and see what the record was on it. It became totally unworkable, and the clerk's office came to us and begged us to stop doing it that way. It's going to be, in my opinion, if you do it that way, as far as for DUI cases, it's going to be difficult, if not impossible, to know what's going on at the time that those decisions have to be made. The DUIs are a special situation because of the public safety aspect of it. DUI courts are supported by the Mothers Against Drunk Driving, and I put in the appendix a bunch of other organizations that know a whole lot about the matter. A guy, though, even who is not, let's say it's a 1st offense DUI, and he comes out of a bar and he's had too much to drink, and he goes down the road 100 yards and realizes, ooh, I have too much to drink. Pulls over into the Waffle House parking lot and falls asleep, and Waffle House people call the police. That guy gets charged with DUI, and that's all he's done. It's 1st offense forever. And he only has the one charge, and it's maximum 12 months. But that guy, in my opinion, should be treated differently than the DUI offender who knowingly goes out on his first offense, knows he's a little tipsy, he may not realize what he's done, but then he cuts other people off on the road, he runs a red light, or he fails to yield the right of way, or goes the wrong way down a one-way street, any number of things. That guy needs to be treated differently than the first-time guy who said, oh my gosh, what am I doing, and pulls over. If we do away with these minor traffic offenses, except in the case of DUI court, then we're doing away with the judge's ability to fashion a sentence based upon that. I will tell you that some people do in fact ask for jury trials for the principle of the thing. I did that on a case I had 30-something years ago, right after I became a lawyer. I'm talking about on my own personal case. And I waited and waited and waited. First I thought I was going to go to jail, because back then the judges, not of the state court, but of the city courts in Cobb, their general practice was if you asked for a jury trial on a minor traffic case, they incarcerated you and sent you in the police car over to the Cobb County Jail, where you had to be booked and had to be bonded. And that was the usual procedure. And I knew that, okay? But the principle of the thing was such that I wanted to do that. And he didn't make me do that. I sat there and sat and sat and sat and sat, and finally said, you can go. And so then I waited for my notice of my court date, and it never came. And so I went to see what happened, and they just said, oh, we can't fool with that. We've already dismissed that a long time ago. So yes, some cases get dismissed, but I have heard more than once, both as a prosecutor and as a judge, people get furious because they didn't get their day in court because the prosecutor dismissed their case. So there are some people that really do come over on those tickets that really are there for the principle of the thing. And also one other thing, and that is there are DUIs that are not, they are DUIs, but they're not strong enough to make, and the judge has nothing to do with the charge. I want you to know that. It's the prosecutor, and the prosecutor decides to reduce it to reckless, but in order to get the punishment up where they want it to be so the person will be properly monitored, they offer a reckless, plus it's going to have the same kind of punishment as everything else. If you can't get the punishment up where that would be, you'll have a lot of cases where it looks like the person's cases have all been dismissed, when in fact, and so they never show up on a driving record, when in fact they've had several arrests for DUI and nobody knows about it. So those are my comments about that, and if y'all have any questions, I'll try to answer them, and if y'all want any more information, then I could. Oh, I did send out to our listserv the question, I'm coming up there, what do y'all want me to say? And the number one thing was, tell them that we've got to have at least 2 years on these cases. The number two thing was, and I want to read you just a second, I want you to read what one of them said to me. He said, how tactfully you ask this question is another matter. Well, I sort of wasn't very tactful last night when I was writing this, so please don't take this the wrong way, and it was kind of tongue-in-cheek. I said, the idea that the majority of traffic offenses should be reclassified seems to be a solution in search of a problem. We're not sure what the problem is, but we stand ready and willing and even anxious to address it at any time. We are happy to be part of the process. Thank you for inviting us.
Chairman Golick has a question for you.
Just to be clear, Judge, no one has said, and this is not to you, this is for your colleagues who may have just innocently misunderstood the mission of both the Criminal Justice Reform Council and the study committee. There's no one has enunciated to my knowledge that the goal is to decriminalize X amount of what are otherwise, criminal traffic misdemeanors right now, or any particular number, majority of them, less than majority, 40%, 60%, 30%, whatever it is, it's just exploring it as a possibility to drive some efficiencies and effectiveness in the system. So I think whoever wrote that may have been under a mistaken impression or assumption.
Okay.
Thank you.
Judge Clayton, we thank you for coming down here today and making your presence felt.
And you might note that I didn't have to talk about my allegiance to the football team because you can tell.
Well, since the University of Georgia brands everything, whether it's moving or not, I can understand that. Well, we're going to take a 30-minute break for lunch. Committee will meet in 6:05 for lunch, and 5:06. 6:05, 50. There's a little dyslexia going on here, right? 5:06, 30 minutes for lunch, and we'll be back. Start at 1:30. We have Mr. Martin from MAD. Is he in the room, Mr. Martin? Yes. That's you. Okay, great. Come on up, and I think most of us know what your organization is, and we know your name, and so you're off and running. Thank you for coming today.
Great, thank you for having me, Mr. Chair. Get organized here real quick.
Thanks.
The packet you have before you is a little bit thick, but I'll try and keep it concise and walk you through it. First and foremost, we're here to talk about support for ignition interlocks for all convicted drunk drivers. As you're probably well aware, we have that mandatory for second time and on, and there has been some resistance, obviously, to all ignition or all convicted drivers being put on interlocks. Our response to that is that first and foremost, interlocks are effective. Centers for Disease Control tells us that interlocks reduce drunk driving repeat offenses by 67%. If it reduces it by 67% for second-time offenders and on, why aren't we reducing it by 67% for first-time offenders as well? An interlock is more effective than license suspension alone, as 50 to 75% of convicted drunk drivers continue to drive on a suspended license anyway. Interlocks save lives. Partly as a result of all offender interlock laws in Oregon and Arizona, drunk driving deaths there are down by 52 and 51% respectively, and that's according to NHTSA. Public support for interlocks for all convicted the public supports interlocks for all convicted drivers, depending on which study you want to cite, whether that's AAA or the Insurance Institute for Highway Safety or the University of Minnesota. Their surveys all say that 76 to 88% of the public would support you if you instituted interlocks for all convicted drunk drivers. All offender interlock laws are widespread. There's a chart in your packet that shows 17 states, including a pilot program in California, have laws requiring ignition interlocks for all first-time convicted drivers. And there's a total of 33 states that have first-time interlock laws. Some of those are for high BACs. And I'll show you later on how that is effective at high BACs, but not nearly as effective for all BACs. So there's a total of 32 plus the pilot program 33 that have a first-time interlock. First offenders are serious offenders. I think there's a misconception out there that we're catching all these social drinkers, these one sip too many drinkers in DUIs, and that's just not the case. The facts don't bear that out. The recidivism rates for first-time offenders are not significantly different from that of second and third-time offenders. In fact, at .08, a driver's critical driving skills like judging distance and speed, steering, visual tracking, concentration, braking, and staying in their lanes are severely impaired, according to a study by Moscovitz. At .08 level, a person is 11 times more likely to be involved in a fatal crash than someone who has had nothing to drink. Interlocks for all offenders will send a message of deterrence to potential drunk drivers, and this is borne out by the statistics in the states that have done it. I'll walk you through the rest of the packet here that I have for you. Next, you'll see an article from the Nebraska Journal-Star talking about their all-ignition interlock law and what it has done for the state. First and foremost, the most important thing that you need to know about Nebraska is that as a result of their all-ignition interlock, their ALR hearings, administrative license revocation hearings, have been reduced by 90%. How? Well, that's because in the year before they instituted it, they were holding 5,150 revocation hearings a year. So far this year, that number's fewer than 500. How does that save them money? Well, that's about 4,500 ALR hearings that are not taking place. That's 4,500 times a police officer is not showing up off shift at overtime rate to testify. And that's assuming that every ALR only happens one time and there's no continuances or nothing else that's happening. So far this year in Nebraska, last year there were 471 appeals to the ALR hearings in Nebraska. So far this year there have only been 8. So you can see the reduction in the ALR hearings alone is a huge savings for the state of Nebraska. In your packet I've also included MAD's model legislative interlock law provisions. These are what we would consider to be the ideal conditions for a all-ignition interlock law. I will leave you to that, but the key here is there is no hard license suspension period prior to the interlock order. It's required for all .08s and above. It is required for anyone who refuses the blow. And it requires lengthier interlock sentences for those who commit a DWI or DUI with a child in their vehicle. Those are the bullet points we go through and provided you with a section-by-section explanation for those provisions that we would like to see in the law. If you'd like to discuss those, we can. If not, you can look at those later. Okay. The next thing in your packet is a survey of currently installed interlocks in the United States. This is a study done by Richard Roth. He's a PhD. And essentially the bottom line learning here in this study is that interlocks per fatal alcohol-impaired driving crash by states are reduced when you have all-ignition interlocks. For those states that we have significant enough data in order to make a decision, we can see that, for instance, in Arizona, they have reduced their drunk driving deaths by 51% after their all-ignition interlocks. States like New Mexico have been reduced by 28%. Meanwhile, here in Georgia, with just a second-time interlock law, we're at 19% since the second-time interlock law has been implemented. In other words, we could see an increase of about 30%, or better put, a decrease of about 30% in the number of deaths on Georgia's roads if we were to implement an all-offender interlock. To put that in perspective, that's about 90 deaths per year here in Georgia that could be averted. The last thing in your packet is actually the data that supports that. You'll have 3 columns or 3 sections of data here. If you take a look at those states where we have significant data, for laws requiring or highly incentivizing ignition interlocks for all convicted drunk drivers, in Arizona you've got a reduction of 51%. In Louisiana, reduction of 39%. New Mexico's reduced by 29%, and Oregon by 52%. That's reductions in deaths as a result of a DUI. Now, I mentioned earlier that there are some states that are doing first-time interlocks for high BACs. That's BAC of .15 or greater. We can tell you that those do work as well. .15 or greater has reduced the deaths in Florida by 25%. And the deaths in West Virginia by 38%. However, those seem to be so far anomalies where if you take a look at New Hampshire, North Carolina, and Texas, those are 4%, 7%, and 5% respectively. So you can see there's a huge difference between the percentage of lives saved with a high BAC and the percentage of lives saved with an all BAC. You compare that with laws requiring interlocks for repeat offenders such as Georgia, and we are right about the national average at about 19%. The national average is about 18.5%, and so we have a ways that we can go. Our laws are effective. They are saving lives, but there is certainly room for us to save quite a few more lives. Excuse me. And that is the packet I presented you. I'd be happy to entertain questions at this time.
Questions from the committee? Mr. Martin, I have a question for you.
Sure.
I'm going back to this little NCSL presentation that they did from earlier this year. And just in scanning this, I mean, what it doesn't tell you is the per capita information. You got some of that in your in the stuff that you presented to us, from what I can see, and just looking over it.
Yes, the Roth data is per capita.
But you know, you mentioned the Nebraska story, and I'm looking at total traffic fatalities in Nebraska at 257, and alcohol impaired fatalities at 51 for a 27% alcohol impaired, which is 3 points higher than what Georgia is, with about 1,250 fatalities and about 300 alcohol impaired from this information that came from NCSL. I mean, does that compute?
Well, I'm not sure. I haven't seen the NCSL data. It depends on what year the data is.
Well, what this would lead you to believe is that alcohol impaired fatalities, you know, they run like they've got Wisconsin at 36%, and they've got Delaware at 36%. Let's see what Texas is. Texas has the most number of impaired. Texas has alcohol impaired fatalities at 42%. Yet they have the most number of interlock devices installed.
Yes, if you look at the Roth data, however, let me find Florida. They have had a reduction of 25%, and they're a high BAC all interlock. So, again, the data would suggest that a lower BAC would give you a higher result.
Yeah, well, I think they're at 27%. By the way, they're higher still than Georgia is right now in terms of fatalities per. With a BAC above 0.08, and, you know, and anybody can make anything out of data to some extent, but it's just on a cursory look here. I mean, it kind of you'd think that this would work in terms of the 0.15 or the, you know, or all interlock for any first offense type of thing.
Yeah, I think the difference here is that the percentages you're quoting are per motor vehicle fatalities.
They're fatalities over BAC above 0.08. Yeah.
That's correct. But if you look at the rank in terms of IIDs per fatal alcohol death crash, they're ranked 30th, whereas Georgia's ranked 38th.
Okay, so you're saying there's room for improvement, basically.
Absolutely.
is what you're really saying, and that's.
And again, the data doesn't say every time you do this you're going to get a 50% increase, but it certainly bears out that the lower BACs get a better result than the higher BACs. There are a couple of states, as I mentioned, that have the high BAC law, and they're doing quite well with it. West Virginia at 38% and Florida at 25-26% reductions. So you can have the high BAC and get a significant reduction. But clearly the 50% that you're getting out of Oregon and Arizona would suggest that the 0.08 would give you a better result.
Is there any place that offers the judge the opportunity to give an either-or type of thing, or where you can have I'm going to give you a choice. You can be suspended for whatever, or you can have a first-time interlock installed.
Yeah, in fact, there are 11 states, including California, that are not mandatory interlocks. It's completely at the discretion of the judge. You can look on this sheet that is in your packet, and that'll show you those on the right-hand side. I'd have to take a quick look here and scan. Let's just grab one out of the air here with Kentucky that I see here, and let's see where their results are. See if I can find Kentucky results. Yeah, I'm not finding any Kentucky data in here, so at least the data I have doesn't really show me much. Let me see what the Roth data says real quick. Kentucky is ranked 46th in their IIDs per fatal alcohol death crash. So you can see then that the not mandatory is significantly worse than the mandatory. Then if you go to the interlocks,
Yeah, but that's mandatory in everything, right? I mean, in other words, if you had our second offense mandatory requirement, but on the first offense you gave a option, is that what you're talking about, or not?
No, in the
if
case...
If it's all non-mandatory, then it's hard to compare.
Right.
Okay.
But you can tell that on page 4 of the Roth data that Kentucky is second to last in terms of their effectiveness in using that system.
Okay. But that's all mandatory, or all the non-mandatory?
That's all non-mandatory,
yeah,
correct.
Right.
But, it bears out, it bears repeating or mentioning here that even though interlocks are supposedly mandatory on a second-time DUI here in Georgia, we've only got 2,200 interlocks installed in the entire state. And so judges are using their discretion despite what the law says. And so there is some disconnect there between, is it mandatory or is it at the judge's discretion?
What's the conviction rate?
I don't think we have that data. I don't think that's even available.
Okay.
We do know that there nationwide are approximately 1.4 million DUI arrests. Approximately 1 million of those are convicted. But again, that is extrapolated data from NHTSA, and here in Georgia it's particularly difficult to get to drill down that deep.
Okay. Chairman Golick, you have a question.
Thank you. Just following up on that discretion issue, are you saying that right now the state of the law in Georgia is that on a second it is required, but that judges are not following the law? Is that what you're saying? And you're basing that on what?
That's based on anecdotal evidence, I would say. We have no way of verifying that other than 2,200 is an awfully small number for the number of DUI arrests that we suspect are happening. I'm told that there's as many as 5,000 arrests a year, and if that's how many arrests there are, and we've only got 2,200 interlocks going on, there's...
Okay, I mean, 5,000 includes first time.
I'm not in a position to editorialize on what's credible and what's not, because I know what I don't know. But
good point.
I mean, it is a fairly serious thing to say that, to make a blanket statement that we have a requirement on the second and judges are not doing that in the absence and are not following the law. Well, that's what you just said.
I apologize. That's not what I meant.
Okay.
You
want to clarify?
I have been given instances where those interlocks are not being assigned.
Okay.
So I know that it is possible, and I've had judges tell me that they haven't assigned it.
And I would agree that it is possible. I just think I think it would do better for anyone advocating the position, and certainly for our edification, if there was some data to back that up.
Agreed. Apologies.
No, not at all. I want to make sure I understand it, first of all, more than anything else. And just to follow, Mr. Chairman, on the issue of discretion, right now, do judges have the discretion now on a first to impose an interlock?
I don't know for sure, but I would assume they would. I don't know.
Okay. I would imagine that they would. I see a judge nodding, so I take that as a yes. So, that's always a good way to... Right. And I just wanted to get that said out loud by somebody that... so they have the ability and the discretion right now to go ahead and do that, but they're deciding perhaps in some cases that it is appropriate, and in some cases perhaps that it isn't. I don't know, and I'm not a judge.
Point taken.
I don't pretend to be, other than Judge Rice, of course. But but I mean, this is really, I'm trying to distill the issue in my mind to get my head around it. It seems to me if they have the discretion, if it's the law right now on a second, and they have the discretion on a first, the real issue was whether or not we want to just go ahead and mandate it and take away judicial discretion on that, which I'm not editorializing one way or the other, but that really is what this is coming down to, I think.
Yeah, I understand the issue with judicial discretion, but I also know that the initial data coming out of these all offender interlocks is very positive in that it is saving lives, and so I come down on the end of let's save lives, and I understand that a judge is a judge and they want to judge, and they want to use their experience and their knowledge to judge each individual case on its merits. And so I can respect that. I can understand that they want to do their jobs and they want to do it well. But at the same time, I do know that all BAC first-time offense saves lives.
And I'm just to be clear, I'm not dismissing that. I'm the guy who earlier today said, look, we have quantifiable, we have data that suggests if you reduce the number of teenagers in a car, that's going to reduce the number of collisions and fatal crashes. We know this statistically.
Absolutely.
So I'm not dismissing the data, and I take it very seriously, but it is a balance between, you said about the judge, there is a balance to be struck. You mentioned how the judges want to do that. They may or may not.
Right.
They may or may not, but I think when you take a giant step back on that issue, it isn't so much the issue of the judge may, in his or her discretion, impose an interlock or not. The people have elected that judge to make that decision. That's where I think I'm coming from a little bit more right now.
Sure.
And that, are they striking that balance? Are voters going into the ballot box and voting for a state court judge because, I wonder if they're striking a balance on interlock devices on DUIs? No, they're not thinking about that, and I'm not saying that. But there is a little bit of a higher priority here in terms of, are we going to go ahead and mandate it or trust that discretion? That's a very tough call. It's something that I've got to get my head around a little bit more, to be honest with you. But I don't think it's as simple as we need to do this, and now we're all for public safety. We want to enhance public safety. We all want to save lives, but we also have individuals who are charged in to make those decisions. In some cases, it may be valid. In some case, it may be called for. In some cases, it may not. That is why we have judges, and I think that it's a tough issue. It's not quite as straightforward as some folks may think.
I do understand the dilemma, and I also recognize that we have a limited data set, but that the initial data set is very positive.
Thank you.
Any other questions for Mr. Martin? Mr. Martin, thank you for doing what you do and coming up here and telling us about what your thoughts are on interlock devices and what they do for us. I appreciate your comments on this. Thank you.
Great. Well, thank you for having us.
All right. Okay, we're going to, let me just see here. Why don't we move to Barry Schrank? Barry, why don't you come on up? You can tell us about your concerns about the various driving school issues that you've been bringing to our attention on a regular basis over a series of years. Thank you for your service.
Thank you, Mr. Chairman, Mr. Co-Chairman, members of the committee. My name is Barry Schrank. I'm president of Taggart's Driving School. We're headquartered in Tucker, Georgia. We've been in business since 1957. I purchased the company from Mr. Taggart in 1976. And you're right, I've been coming down to the legislature for almost 30 years, working on mostly in Title 40 and working on issues in Title 43 also, which are tied together with the driving schools. I also represent the Georgia Association of Risk Reduction and Defense of Driving Educators. Most folks refer to it as GARD, which is our industry association. There's also another association that I don't represent, and although I have worked with in the past. Basically, our members operate driving schools that teach people how to drive behind the wheel, mostly adults, and then also teach the Teenage Driver Education Program, which you heard testimony earlier today from the department. Generally consists of 30 hours of classroom and 6 hours behind the wheel. We also provide third-party service in that we can, if a student has completed a driver education program with our school, a teenager or an adult, they can actually take the road test with one of our licensed examiners. Those examiners go through the same training that the examiners with the department go through, and we have a certified road test that the these individuals take, and we use the same materials, the same standard grading as the department does, and that's an option for parents to take the road test with the driver training school that provided their teenage driver education program. We also operate driver improvement schools, often referred to, as was told you before, as defensive driving programs, a 6-hour defensive driving program used for license restoration, ticket dismissal, points reduction, and also for insurance purposes, insurance reduction purposes. And many of us also operate the DUI risk reduction programs, all licensed by the Department of Driver Services. We also teach there's a limited number of schools that teach the 4-hour alcohol and drug program that is required from every applicant for a driver's license under 18 years of age that wants to get a driver's license. They have to take that ADAP program and pass it before obtaining a driver's license if they're under 18 years of age. Several of our members are also ignition interlock providers. Our particular company does not provide that service, although we support that program. We think it's a great program. And so basically that's what we do in our business. That's all in Title 40, mostly in Chapter 5 and Chapter 6, and also in Title 43, where we are licensed and the outlines for operating a driving school are listed in the law. We have several recommendations and also concerns, and I'll start with driver education. We have a problem with some public school competition. For years, up until 1985 under QBE, the public schools, most of the public schools taught driver education. Once QBE was implemented, it was no longer funded. The driver education program was no longer funded, and most of the programs, most of the public schools looked at the cost of the program and dropped driver education in the public schools. It was reinserted in QBE, I believe it was in 1991, maybe 92, and it became a QBE authorized subject, but still, because the public school systems had looked at the cost involved in providing driver education programs, they decided that they were not going to implement it, and most of them did not for many, many years. Some had after-school programs, and those programs were actually very important because in those years, driver education was not offered in many counties in the state of Georgia, either by a private provider or by a public school. So when the public schools offered it and there were no private providers, I think that was good for the county and good for the teenagers and good for public safety. The problem is that has developed is some of these public school systems are actually in competition with the private schools, with their after-school programs. We know for a fact, just based on general business knowledge, that the public schools cannot be offering the driver ed program to students in their county and adjacent counties, and also to private independent schools in other counties, and charge the prices that they're charging. They just can't meet their expenses doing that. I know of one school system in the metropolitan Atlanta area right now has $500,000 in cash set aside in their budget, money saved allegedly from operating their driver education program, after-school program. That's impossible. I don't think there's a driving school in the United States that would have $500,000 in cash just sitting there waiting to buy cars sometime in the future. There's just not that kind of money made in driver education. So basically what is happening is these school systems are providing these driver education programs at less than cost. Now I say that because our driver ed program at our Tucker location, East Cobb location, South Lake location, I could go on and on, for 30 hours of classroom, 6 hours behind the wheel is $459. The school system, one of the school systems, these school systems I'm referring to, charges about $340 for that same program. It's impossible. It cannot be done. I say it can't be done because over the years that I have been in this business, I've spent a lot of time looking at other states' programs and what they have done. 15 years ago, the state of Texas dropped driver education because they determined during a budget crisis it was costing them $1,100 a student to teach the driver education program. But of course they were charging $195 for the program. So when this budget crisis came, they dropped the program. 2 years ago, maybe 3 years ago now, during the last cutbacks that the governor at the time, Governor Perdue, made with respect to the money sent to the public school systems, DeKalb County had a driver education program, an in-school driver education program. It was free, and I have no problem if a driver education program is taught in school free as part of QBE. My problem is with the after-school programs. But in any event, I'm just telling you this information to confirm what I'm saying with respect to predatory pricing, as we call it, with some of these after-school programs. DeKalb County was notified that they were going to lose $25 million more in funding from the state of Georgia. And at that time, the superintendent said that all the programs in DeKalb County schools were going to be looked at and determine what they're going to keep and what they weren't going to keep. Well, they dropped their driver education program because of the cost of it. After they dropped that program, I went to a board meeting, the school board meeting, spoke to the superintendent and said that we provide driver education programs to some school systems, and I'd be interested in talking to you about providing it in DeKalb County. He said, fine. He said, I don't have time. He said, I'm very interested in it, but I'm going to assign you to a deputy superintendent and assistant superintendent, and they will call you. And sure enough, they did call within a couple of days, and I met with them, talked to them, explained we could provide a complete turnkey operation for a school system, 30 hours of classroom, 6 hours behind the wheel, pick up at home for the in-car training, provide textbooks, all the materials for $435. When I said that, the assistant superintendent said, that's amazing. It was costing us $1,800 a student to provide driver education. And that's why we dropped it. So when I walked out of that meeting and I thought about it, and I said, well, that's probably true. There's no reason for them not to tell me the truth. And it's probably true because at that time, 15 or 16, whatever number of years ago, when they did a major study in Texas Department of Education, it was costing them $1,100. So I could see where the cost would go up from $1,100 to $1,800 in 15 years. So we have a problem in that we're competing. We pay school taxes, and then the schools turn around, public schools, and this one particular school, and I'll tell you what school it is, it's Marietta City Schools. They teach the program in the county, in Cobb County. They teach it in an adjacent county, and they even teach the driver ed program at Westminster Schools. Well, Westminster School is probably, I don't think I would get much of an argument in this, probably rated as the top private school in the Southeast. You don't get much better than Westminster. And the tuition's pretty high there. I would estimate it somewhere between, if you want to send your child to 8th or 9th grade, it's probably $22,000, $24,000 a year, somewhere in that range. And we had the contract to teach driver education program there. We lost the contract because Marietta City Schools came across the county line in the Fulton County from Cobb County, bid on the program, and I lost the program. I just don't think that's fair. I don't think that's what should happen when there's a public-private partnership already established. And so I have a problem with it, and our membership has a problem with that, and it goes on around the state. I don't think to the extent with the Marietta City Schools, where they're crossing county lines and also teaching it for private schools, private independent schools. But it's a problem, and there was a bill addressed this past session. In fact, there were a series of bills addressed this past session, starting with House Bill 1133, 34, 35, 36, and 37. 3 of the bills went to the House Motor Vehicle Committee. 2 of the bills went to the House Judiciary Committee, non-civil. And at the time, I believe the decision was made to hold off on looking at these bills, looking at this information, and waiting for these hearings to happen during the interim. So there has been some research done, and there has been legislation introduced that addresses some of these problems. The way that particular problem will be addressed for the public schools, if they're teaching an after-school program, we recommend that they have to provide good, solid accounting information according to standard accounting principles about their actual cost for these programs. And that if there's a private business, a private school, operating in that county or in that district, that they cannot undercut them. First of all, they would have to make the contract available on a bid. We have no problem with open bids. Make the program available on a bid, and also provide to the General Assembly and the Department of Education the true cost of what these programs are costing, and not hide their expenses in various budgets within the school system. That is our recommendation. There's some other things that we wanted to talk about. Chairman Golick mentioned the concern that he has with his 11-year-old, and I hear that all the time. Parents, mostly of 13 or 14 or 15-year-olds, that they're going to drive, and I think that's probably one of the scariest times in a parent's life is when their child leaves that driveway for the first time with a driver's license, and they hope everything goes okay. You've heard testimony from the department, I believe, that the Joshua's Law, the requirement for 16-year-olds to take driver's education, and also TADRA, has worked very well. It's not only worked well in this state, it's worked well throughout the country. If it weren't for graduated driver's licensing, I don't believe we would have the reduction in deaths we have throughout the country. It's very, very important. I used to think many, many years ago that driver education was the key. It is still a key, but it has to be in conjunction with graduated driver's licensing, and it has been proved. There's been studies done after study done that's what is necessary. Our suggestion is that instead of our suggestion is to change the law to include anyone under 18 to take mandatory driver education. My opinion is, and I think most people that are in this business and have been in it for any period of time, that a 16-year-old without driver education is just as dangerous on the road as a 17-year-old, or vice versa. And we may want to step up to the plate. I think Chairman Golick mentioned that he wasn't there when TADRA was first passed. I thought you were, but maybe not. You weren't involved in that committee. A lot of it was done in the Senate with Congressman Phil Gingrey. He was involved in it. Several others that are no longer here. But in any event, the plan was at that time is to make it mandatory for 16-year-olds and then maybe go up to 17-year-olds after we saw what the results were. The results are in. The results are excellent. And so our suggestion is to change it to under 18 years of age, where they have to have driver education. Something else we'd like to recommend, it's very easy to get into the driving school business. Basically, you apply for a license with a department. As long as you have a clean criminal record, you're fingerprinted, your fingerprints are sent to the GBI and the FBI. You have to submit a curriculum, which is not very difficult to get. Pay your fees, get your business license, and basically, you're in the driver education business. It's very easy to do that. Some of these schools stay in business, and some don't. They go out of business. Our suggestion is there should be some mandatory training required of the instructors. When we hire an instructor, they go through a complete interviewing process. And of course, we don't have to do much of a background check because we send their application in the Department of Public Safety, in the Department of Driver Services, and they do the background investigation. But except for a short 3 or 4 hour training program at the department, and they do a great job, but basically it's no more information provided to the instructor than you can find in a driver's manual. We believe that the school ought to be responsible for submitting a curriculum to the department and then certifying that their employee who's going to be a driver ed teacher, they have gone through that program. All of our instructors go through a 3-week training program. The first week, they learn what's taught in a 30-hour driver education program and spend a lot of time learning traffic law because that's what they're going to have to teach. The second and third week, they learn a series of 21 separate hours of instruction that they're going to be teaching their students in the car. They see training films, they take tests, and then they go out and a senior instructor, a training instructor, teaches them how to teach the in-car lessons, and then they have to teach the lessons back to the teacher, back to the training director. And when they go through that training program, they're pretty well trained. But I will also tell you in honesty that it probably takes from 3 months to 6 months implementing all that knowledge they have learned in that 3 weeks before they become what I would consider a good instructor. But right now there's no standard for training. We're not looking for an opportunity to set up a business to train instructors because school owners can set up their own curriculum, submit it to the department, and then just certify that an instructor has been through some training. I know, because I've been in this business for so long, over the years, I've had any number of instructors, licensed instructors, come to me and say they want to go to work for Taggart's Driving School. And one of the first questions I ask them is, well, what kind of training did you get before you became an instructor? And the answer is almost, in many, many cases, that, well, I sat in the back seat of the car with a licensed instructor for 4 or 5 hours while he was teaching a student. And then, I took my test, my 100-question test with the department. I got my license, and that's the training I had. And they're sort of proud of it. And I'm sitting here thinking, well, if we do hire you, you're going to have to go through our 3-week training program because I'll be the last person to put somebody on the road in one of my cars with our name on it that hasn't had any kind of training. But there's no standard, and there really needs to be a standard for these teachers. Now, if an individual comes to me and he has what used to be 15 quarter hours at the college level in traffic safety and driver education, then they're pretty well trained. They'll put them through an abbreviated program. But they need some training. And there are a lot of instructors out there today, and I'm probably going to have representing school owners sitting here listening to me that don't agree with me. They're going to be awful upset with me. But I will tell you, don't have the training that they need to be teaching kids how to drive. And they spend 6 hours with them going around the block, teaching them how to parallel park, weave through the cones, reverse straight, reverse driveway so they can pass the test. And then they sign a certificate, and now they have a driver's license. So just a recommendation to you. I also want to talk about driver improvement programs. And there's under the code section, under Title 40, driver improvement can be the 6-hour defensive driving program. And the code section is so convoluted, it can also include DUI risk reduction programs. But I want to talk specifically about the 6-hour defensive driving program. 30 years ago, there were many, many counties in this state that did not have a private program providing 6 hours of defensive driving that was needed for individuals to get their driver's license restored or to meet court order that they attend a 6-hour defensive driving course. So if you lived in South Georgia, especially south of Macon, you might be driving 75 miles or 80 miles to get to a 6-hour defensive driving program. Today, that's not the case. There's programs throughout the state of Georgia in every county. You don't have to drive very far for a DUI risk reduction program or the 6-hour defensive driving program. It's a public-private partnership that the House Motor Vehicle Committee, mostly over the years, have developed and made the changes in the laws. The problem that we have now in private industry with this public-private partnership is that some of the courts are developing their own driver improvement programs. And I have copies of a newspaper article from my home county, actually, DeKalb County, where it's very clear, contrary to what the judges testified to today, and I believe the judges in their courts. But in DeKalb County, in a recorder's court, they're very proud of the fact that they have set up these various programs. You can get a GED in recorder's court, take a happiness and driving course, all these different courses that are offered by the recorder's court in DeKalb County. And it's very clear from the newspaper article and a public program that I attended with the recorder's court open to any citizen in DeKalb County. It's all about money. It's raising money, how much they can raise for the court system. So what's happening, just as an example, you have a soccer mom who goes to a recorder's court, and she's going through a stop sign, maybe slid through a stop sign and got a ticket. The judge will tell them that, listen, we'll dismiss this ticket, but you have to pay us $300 to go into a diversion program. And once you're in the diversion program, you have to pay $65 for the course that we're going to teach you, that I'm going to assign to you. Well, I will tell you, for those folks who don't have much experience with the court system, that when that soccer mom walks up there and she's looking up at the judge and the judge makes this offer, she's probably going to take it. And that's exactly what happens. They've come up with their own driver improvement programs. This is a new wrinkle. There's always been, in certain places around the state of Georgia, courses that were offered or taught by, a friend of the court instead of going to a licensed driver improvement school. All these licensed driver improvement schools, when I say licensed by the Department of Driver Services, the curriculum is looked at. They send in monitors to make sure that the courses, the class starts on time, that nobody gets out early. It's completely monitored by the department. They do a great job on it. And no one knows what these courts are teaching, and especially when the judge says, listen, see that man sitting in the back of the courtroom? He teaches a little defensive driving course on Saturday afternoon in his basement. It's going to cost you a little money. Go on back there, bring me the completion certificate, and I'll dismiss the charges. It happens all the time. Not in every court, but there's enough courts and there's enough school owners around that I've heard that story any number of times. I can provide, in fact, some of the members of the committee have seen the articles in the newspaper, and you can go online, DeKalb County Recorder's Court, and everything I have just told you about that court is actually laid out there, that what courses you can take and how much it's going to cost and everything else. The General Assembly set up a public-private partnership and has all these schools set up with the Department of Driver Services monitoring us and licensing us our programs. And I think it's wrong. As a citizen, I think it's wrong. As a taxpayer, I think it's wrong that shouldn't be happening. That the courts are not in the business of providing GED programs or these other programs when the General Assembly has already set up programs throughout the state as private business. With respect to the DUI risk reduction program, you heard information from the department today. There's a couple of problems there. There is a lot of non-compliance. I know as a licensed risk reduction instructor that over the years, any number of people have come through the program, and for whatever the reason is, they have delayed taking the risk reduction program to get their driver's license back. In the days when we would have 10 people in the class, that we probably have 9 of them who drove there. 4 of them would park outside my office, which is right on Lawrenceville Highway, not too far from a police precinct, And 5 of them, or excuse me, another, 5 of them, the smart ones, they parked across the street in the apartment complex and walked out of here and walked into the apartment complex. But they all drove, and they don't have a driver's license. So, and the problem is, not with so much with the accountability courts, which do an excellent job, but with just regular DUIs, a first DUI or maybe a second DUI, is that they're on probation for a year. So by the time they pay their fees at a probation company, a private probation company, pay their fines and do their work service or whatever they're going to do, the probation time is up, and they haven't gone to the risk reduction program. Well, by state law, they have to take the risk reduction program, or they can't get their driver's license back. The simple solution is to say in the law, while the private probation officer still has control and the court has control, is that they have to complete the risk reduction program within 120 days of the offense or the conviction or release from incarceration, when the private probation officer can make sure that they're doing these things. Because if they go the year and they're off probation, or if they get off probation, maybe they pay the fine in 6 months and they're off probation, they're going to drive for a long time, and they're probably not going to get caught. So we suggest, and it's in that legislation I talked about earlier, that they be completed within 120 days. Here's another problem that we see with the risk reduction program. If you get your DUI, you're convicted in court, you then have to go to the risk reduction program and take an assessment. It's $82. That was already explained to you by the department. Then you take the 20-hour course. You may have to take, if you're a second offender, you have to take a clinical evaluation. We hear it all the time, people going through the program, and they'll take a clinical evaluation with us because we offer that service, and most schools do. That person will come out of the clinical evaluation and say, this is unfair. I've just paid you all $100 for the clinical evaluation. I had to take one in the beginning of the program because the court required a clinical evaluation. So they're hitting them in the beginning and they're hitting them at the end for the same clinical evaluation. Research has proven that the clinical evaluation is much more accurate after the individual offender has taken the assessment and gone through the 20-hour risk reduction program. And then if the clinical evaluation says that they need treatment or they need to go to AA or whatever they happen to need, it's a much more accurate clinical evaluation after they've gone through the program. I don't know what the answer is. All I can tell you is that our fellow citizens are getting hit in the beginning and they're getting hit in the end. They're paying for the same thing twice. And from a research standpoint, an education standpoint, from a changing behavior standpoint, that needs to be done, the clinical evaluation at the end. The other thing is, we believe that the offender should have the right to go to their own clinical evaluator who is licensed by the Department of Behavioral Health, instead of being told by the probation officer or the court they have to go to a certain location. In Gwinnett County, for example, if you go through the risk reduction, if you're arrested for DUI and convicted, you are told you have to go to a certain government-operated facility for the clinical evaluation, and in most cases, the treatment. We don't think that's fair. There are any number, hundreds and hundreds, thousands throughout the state of Georgia with a proper educational credentials and background that can provide clinical evaluations and provide treatment. We don't believe that a probation department or the court should be telling somebody that they have to go deal with a certain company. I mean, it'd be great if it was my company, but it's still unfair. And that needs to be changed. The other thing that happens is when they go to some of these clinical evaluators, a lot of them are not licensed by the Department of Behavioral Health. And they'll send them through a program that courts will sometimes accept, and it's a 2 or a 4 hour program. Well, I submit to you, you're not going to change anybody's behavior that's had a second or third or fourth DUI with a 4 hour treatment program. It's just not going to happen. but they're getting caught up in that too because the clinical evaluator they're going to doesn't have any ethics, and they're saying, well, we can do this, and then they take it to the court. So just some suggestions. With respect, I want to drop back one more time to the 6-hour defensive driving course. There was a law passed a year ago, not this past session, the session before, that directed courts not to accept any defensive driving program certificates from unlicensed programs. Went through the House Motor Vehicle Committee, went through the General Assembly, passed overwhelmingly. But I think what some of these courts are doing, not all, and I doubt if any of the courts where the gentlemen and the ladies sitting here are involved in it, I'd be very shocked. But in some of these courts that are providing their own little programs, I lost my place here. Yeah, okay. Any event, the law says you're not supposed to do it. But I think what the courts who are doing this program are relying on is pre-trial intervention and diversion 15880. And they're saying, well, the law says here I can do it, even though in Title 40 says I can't. So I think that needs to be addressed, and I think that's the answer or the solution to the problem.
Thank you. We have a question from Chairman Gola.
Thank you, Mr. Chairman. Mr. Schrenk, I want to go back to an issue that you brought up a few minutes ago, and I want to make sure I understood it and heard it correctly. This has to do with, and what I just heard a second ago was that there's an inconsistency within the code about one code section says that a court system, a county, a particular jurisdiction can have its own program, whether that's an evaluation or risk reduction or whatever it may be, and they can go ahead and suggest that to an individual who may need to go through a program like that. So if there's an inconsistency in the statute, and one statute says they can do it, one statute in Title 40 perhaps says they can't, I hear you loud and clear when you said that it has to be clarified what it is that they can or cannot do. What bothered me, and this is several issues ago that you spoke about, and if I heard it correctly, was that did you say that there are court systems in the state that are where a risk reduction program is mandated, that they are either via their website or a particular judge or a particular custom and practice in a particular circuit, is that they are saying, Mr. Smith, you need to go to this guy or that guy or that guy, and there's basically ordering, not technically, but they are steering an individual who, in order to comply with a court order, needs to go through a particular program, and they are steering that individual to a particular business in order to fulfill whatever requirement of the court that is. Is that what you're saying?
There's two different issues.
Okay.
One is the DUI risk reduction. The other is a 6-hour defensive driving program.
Okay.
With the DUI risk reduction program, the offender is required to take the clinical evaluation to go to treatment at a certain location, and they're usually government operated, like in Gwinnett County.
Okay.
With the 6-hour defensive driving program, it's not unheard of for a judge to tell an individual to take an unlicensed defensive driving program, bring the certificate back, and they'll dismiss the ticket.
Okay, so an unlicensed defensive driving program.
Yes.
So they're basically steering them to an unlicensed program. Is that in noncompliance with the law as you see it? In other words, are they?
Yes.
That's specifically called for in the applicable code provision? Excuse me, hold on a second. It's specifically, if I hear you correctly, because it's a pretty serious thing. I mean, they're specifically steering an individual to a defensive driving school that is unlicensed and telling them, go to my guy, because that's what it is.
Yes. Yeah.
If I'm hearing it correctly, go to my guy, go to my buddy over here.
You heard me correctly, Mr. Chairman.
Bring back the piece of paper.
Yes.
Which may or may not have a net worth to it, and I'll dismiss the ticket.
Yes. It happens with private individuals, and it's happening in DeKalb County right now in Recorder's Court because their program
Yeah, you mentioned that.
is unlicensed.
And there's a specific provision in Georgia law that requires that particular program to be licensed and or I guess approved by DDS. Is that a correct statement?
Yes. Yes.
Okay.
In fact, the last time, it's been addressed 4 or 5 times.
Mhm.
The language has been changed in Title 40 in the House Motor Vehicle Committee 4 or 5 times over the last, well, 3 or 4 times over the last 10 or 12 years, trying to solve the problem. It was just addressed, was it House Bill? I have it here. I can find the bill. It was addressed, and even the Department of Driver Services, I believe legal counsel, sent a letter to one of the members of the committee saying that this change in the laws had solved the problem. The department was under the impression it was going to solve the problem.
But surely the court systems, have to know that if they're going to mandate some sort of defensive driving as part of a plea, that has to go to, it has to be done through a licensed or approved or whatever the euphemism is, school, right?
I would think so, yes, sir.
Okay. Would you be willing to reduce what we've just talked about to writing?
Yes.
Thank you.
I can show you the copy that I printed off the website.
Thank you.
Yes.
Thank you, Mr. Chairman.
All right, I'm going to recognize Alan Powell here for a second, then Jay, you got your next.
Thank you, Mr. Chairman. Let me see if I might can help add to this. You know, 22 years ago when I first came onto this committee, we had a quasi-relationship, the state government on DUI programs and risk reduction programs. At that time, quite frankly, we didn't have the problem with a lot of the courts of inferior jurisdiction that were doing these type of things. Historically, what we went into, or what we wound up to, when we started getting tough on the DUIs back in the 90s, our whole position was trying to be sure that these programs were secure positions. That's the reason that we had investigators that were going out so they wasn't selling certificates to the DUI schools and stuff like that. And, you know, it appeared that the tougher we got on the DUIs, historically back through the 90s, apparently we gained some sympathy, or some of the DUI offenders gained some kind of sympathy. And the courts at that point started, and there was some steerage back at that point. There were certain schools that are out there, and judges would specifically say or point out to offenders. Now, this was back in the 90s, and then that was the first time that we started trying to hem this problem up. We put the language in statute that said that the courts could not send someone to a specific location. And then it went on a few more years, and what wound up happening is this invent of a lot of the courts of jurisdiction, and I think it was more under the, not so much the DUI schools, because they couldn't, that's clearly in statute. If there's a DUI made, as conditions of getting that license back, you had to go through this procedure of assessment and the school and all of this. So I haven't seen a lot of problems with the DUI schools as per se of any of that steerage. But what has happened under the defensive driving schools, and Mr. Shrink has told us straight up, because I had a fit last year when I looked at this website, and it was DeKalb County, it was the Recorder's Court. And it was systematic of what we're seeing in a lot of the courts. They will set up, generally under their court, a school or a course, which might be some of their employees, the clerks, or somebody. And they use this as a diversion. If you have an offense, you go to the court-ordered, our court program. Well, once that's a diversion, they can drop it, because the only time that you need to go to the licensed is if that offense continues to be. This is sort of go to my course, and that fence is going to go away. I mean, that's quite frankly what it is, and it's sort of like, you know, when you're dealing with this stuff, it's like hemming up mercury. You know, every time you put your finger on it, it splits 3 different ways. And I mean, that's exactly what we've been dealing with for years of trying to do this. And I want to, while I'm at it, I want to go ahead and address, and I'll be finished, but I want to address Mr. Shrink's concerned about the driver improvement competition. I don't know if there's any way that we legislators, under this quote, philosophy of home rule in the school systems, that we can deal with it. But quite frankly, it is not right for the taxpayers of a county to fund a driver ed program that's in competition with the private sector. I mean, it's not that they do it, but it's not right that they do it, because they should be spending their money on more important things, like educating their students and looking after the physical stability of the local taxpayers, instead of being in competition with the private sector. I mean, it just. Thank you, Mr.
Thank you, Mr. Chairman. And if under the law there's if there is a mechanism for a county with regard to Representative Powell's defensive driving school issue, as opposed to the DUI, which is a separate deal, and if there is a mechanism under the law for County X, to take, to bid out that process, for if they're even able to do that within the court system, if there were, there may or may not be, I don't know, and if there is, and that's the way they've gone about it, fine. But of course, the concern that I think I've heard Representative Powell say, I think, which is reiterating mine, is just more of a sweetheart arrangement. I mean, it won't be terribly difficult to go ahead and connect the dots between certain individuals and certain relationships and so forth. And if that's occurring today, that's a very serious deal. That's a very serious deal if a system is engaging in that. And if a system isn't engaging in that, if an individual judge is engaging in that, or an individual public official, that's a huge problem that goes well beyond this room and brings in law enforcement and other more complicated matters. So, and that's why I asked you, is that something that you have, some documentation on? Because if I hear Representative Powell correctly, and I think I do, this is not new, but it sounds to me like some folks just haven't gotten the message. Is that a correct statement?
But I think where the problem is I don't know that somebody'd have to do the audits to find out if money is being, utilized illegally. I think what we're looking at is a vast, as is typical of the problems with all government programs. They start growing and growing and growing. You listen to what we've heard in here all morning today. This system of fines and forfeitures has become more about raising money than it has become about justice and respect for the law. I mean, quite frankly. So if you've got a judge, and if he sets up this program under his jurisdiction as a diversion, I'm going to drop these charges once you've gone through this program. Now, that money may very well go into the court, and it's up to the local counties to do an accounting to be sure that money is going into the coffers or where it's spent.
And just to be clear, Mr. Chairman, no one is saying that they shouldn't set up these defensive driving schools for diversion in order for first offender treatment, whatever it may be. We understand that. And for whatever reason the defensive driving schools are utilized right now, no one is arguing against that. It's when you have these potentially, that's why potentially, I'm not, no one's making a specific allegation, it's where you have these potential sweetheart arrangements where certain individuals who may or may not wear a robe every day when they go to work are steering, and that's a very specific word that I'm using, steering an individual to another individual or business. For what reason? Well, I don't know. The imagination runs wild on that, and that's something that, if that is occurring, is a very serious matter.
In DeKalb County, to answer a question, an assistant district attorney told me in DeKalb County, in DeKalb County, an assistant district attorney told me that the assistant district attorneys are teaching the driver improvement courses. And as a taxpayer, I had just read in the paper where the governor had sent an extra whatever the number of dollars through the budget to the different jurisdictions, the district attorney districts, whatever they're called, because they needed more district attorneys. And I'm thinking, why are you paying a district attorney that salary to teach a defensive driving course? That's number one. Number two, I found it, House Bill 269, passed 2 years ago, 40-5-81, when a defensive driving course is required by a court having jurisdiction over misdemeanor traffic law offenses or by any prosecuting attorney thereof. Such course shall be certified and approved by the department under the provisions of Code Section 40-5. It's a licensing section. That's pretty clear to me.
No, it's not.
It's not?
Would you like me to recognize you?
Yeah. I mean, they have obviously found a way around it because that says when it is required. You aren't required to go into a diversion program. That's an election that you get.
Exactly.
That's where they're getting around it, and because it is not required by the state in order to get your license or to maintain your license. I mean, as a judge, I could say, if you'll stand on your head, I'll dismiss these charges. And that's basically what they're saying is you go to my course and I'll dismiss these charges. And I don't know how we go. I mean, we count on judges to number one, follow the law, number two, enforce the law, and number three, not to have some kind of conflict or ethical issue. And I don't know how we can, legislate down to the last iota, because we do want to give judges discretion. And we talked about that this morning, about keeping discretion with the judges. And yet, sometimes there are a few that will require us to punish the rest of them by removing the discretion. I don't know what the answer is, but I do know I understand the problem that you're addressing. And I don't think that they're violating the law, other than the spirit of it as it stands right now.
Mr. Chairman, if I could just follow up on that. I think if the facts, and of course every situation is factually different, and we all know that. I don't disagree with the word the gentleman has just said. I think that the difference comes in if they're going to go ahead and mandate that requirement, fine. That's part of the system. That's part of, I assume, sometimes first offender treatments for getting charges reduced. No argument on that. That's been around for quite a while and seems to be working very effectively, all within the judge's discretion, assumedly with the recommendation of the prosecutor involved. The problem comes when that course or whatever it is essentially mandated by the judge. That's the potential sweetheart arrangement, if I'm understanding Mr. Schrank's testimony correctly, that calls into question the integrity of that entire process. If that, and I mean just that, is occurring, that's a serious issue. And I think that actually it can be legislated against, but it is enforced by an executive agency that you and I are both familiar with, and that's why we have it. So I'll just leave it at that.
Well, I think probably one of the ways that we could do it is to tweak the law a little bit and say, instead of saying that if it is mandated or required by the court, that we can also say that is a condition of any kind of diversion or dismissal, and we could put that in there, that then it has to be a state approved or licensed course, and that would put a stop to this right here.
Yeah, do it the same way we do DUIs.
Yeah.
That it has to be a state licensed course.
I think that's what, didn't you just say?
On the DUIs, but not on the others.
Well, I think we've probably exercised that one fairly aggressively, and thank you, Mr. Schrank. Are there any other questions for any committee members for Mr. Schrank? Thank you for coming up here today, Mr. Schrank. We really appreciate it. And we are moving madly towards the finish line here. However, Judge Jackson, you have you're supposed to be back in court this afternoon because of your full calendar, right?
But it's a very short presentation. And,
okay.
I want to thank you again for the opportunity to address the committee. The question of who can teach a course and who cannot teach a course is at the core of a problem that I have encountered. I had a policy for anyone over 60 years old or so, if they were found guilty or pled guilty, no contest to a moving violation, typical rear-end collision, nobody hurt, everybody wearing their seatbelts, plenty of insurance. In lieu of a fine, I would send them to the AARP driving course. Of course, you don't have to be a member. Anytime in the next 4 months, they simply take the course. It costs under $15. Mail in their certificate. They don't report to probation except by mail. They have no probation fees. And I simply suspend the fine. I've taken this course myself. In fact, this is the book they gave me. I've taken it 3 times over the last 6 or 7 years to become not only a better driver, but to watch how the curricula changes. And the things they teach an older driver, and I'm 61, are a lot different than what they teach a 16-year-old, because you're dealing with a driver with different skills, different abilities, but a lot of experience. This program has been a tremendous sentencing alternative. It is 100% effective. I've never had a driver fail to complete it. I've never had one of these defendants come back to me in a subsequent accident, not saying they had one. I've taken this course 3 times. I can tell you the teachers are extremely experienced, very conscientious. Not only did I learn to be a better driver, but I saved 10% on my liability insurance for the next 3 years. So I spent $14. I've got a lot of coverage. Saved $147 for 3 years. I call it the Clark Howard Special. And I learned to be a better driver. And because of a change in the law last year, I can no longer use this program. Some of these senior drivers, they're on fixed income. It is a financial burden. But I'm not going to balance the city's budget on anybody's financial backs. And these are the people, most of them, I hadn't been to driving school myself in almost 40 years. I needed to go back. There's some countries around the world, every time you renew, you have to go back. And a lot of laws have changed. When I started driving, the cars didn't even have seat belts. So these drivers needed an update. This has been the best sentencing tool I've ever had. And I would humbly ask that you change the law to put it back. It's something I really can use, and it's been very, very good.
Well, let me ask you a question. Why do you direct them to the AARPs?
I mentioned that as an alternative. I say you can go to AARP. You can go to any defensive driving school. Someone actually asked me, Judge, you're forcing me to go to AARP. I don't believe in some of their political stands. I said, no, you don't have to. You can go to any driving school, and I'm not, by the way, a member of AARP. You can go to any driving school. If you want to go to the regular $75 school, you can. I recommend AARP because it's more attuned to your life skills, experience, and training. It's a lot cheaper. If you want to go to the other school, you can. Or, and I've had some drivers do this, Judge, I don't want to go to school. I'll pay the $293 fine and surcharge, and that's fine too. It's strictly a sentencing option. I've never ordered anybody to take this particular course. I've ordered many to take the standard $75 driving course. That's almost common. You're 80 miles an hour in our courtroom, you're going to driving school. You need to get the points off your record. You need to brush up on your skills. I don't mandate AARP, but 98.9% of the people who are eligible who want to take it, they do. And they go to regular school and spend more money, and I don't think get as good an education. Or they can pay the fine, and a few of those do too.
So I'd be correct to say that you kind of endorse the AARP program?
Yes, I recommend it highly because it's the best tool for the driver my age or older. It's much less expensive, and I think it gives you more benefits. Now, maybe I ought to take the other course as well, but I've taken this course 3 times. It has changed each time I've taken it. And I've taken it with 3 different teachers and each instructor. Each one's actually better than the next. But I'm the first to admit, I'm not a very good driver.
Do you provide a list of alternatives?
Well, I just tell them AARP or any defensive driving course approved by the Department of Driver Services. If they're online active, they can get it. If not, I actually have them printed out. They do change from time to time. Or you can pay the fine. The thing is, and if they want to go to driving school, I sign them up through probation because somebody has to monitor it, but they report by mail and they don't pay any probation fees. They just simply sending in a document. And I've got a 100% success rate.
Chairman Golick.
Thank you, Mr. Chairman. This particular line of conversation stemming from Mr. Schrenk's testimony is so filled with nuance because you're obviously dealing in good faith. You're going on your many years of experience. You have just said that you're not mandating this particular course. You're saying, look, I've got good experience with that in my tenure as a judge. I've taken the course myself. It's fine. There are others out there. You don't have to go to that one.
Or you go to
right. Of course, someone standing in front of you, that's an intimidating experience for an average citizen, and even for those of us who've been around the block a time or two. They're likely to go ahead and go with that recommendation, and I'm not saying in any way, shape, or form that recommendation is made in any bad faith with any nefarious purpose whatsoever. That's clear, Judge. That is, however, a far cry from some other jurisdiction where Judge so-and-so is telling that same person whose knees are knocking in front of him, you need to go to that guy, go do your deal, get the piece of paper, and come back. Really? Why that guy?
That you cannot do.
Well, and apparently from what we're learning, and this is not anything new according to Representative Powell, who's forgotten more about this than I'll ever learn, that's a real problem. So, and that's a real problem that's not going to go away, and it's probably more rife than we know. So that, Mr. Chairman, again, that goes back to that nuance. Your heart's in the right place, but there's something else out there that's not.
At least have an option.
Sure.
Maybe I think I'm going to take the regular course to see how different it is.
I can direct you to a school where you might be able to.
Well, if there are no further questions, I've got about 120 cases, and by the way, I'm just one of 7 other judges down the street. We are the busiest traffic court in the state of Georgia. Us and Judge Nellie out in Recorder's Court, and there are a lot of unintended consequences. The phrase that I heard among the other judges, there are a lot of moving parts with this. I just want this one part back, so at least it's another arrow in a quiver that we can use. And you're correct. A judge with reasonable conditions of probation could do a lot of things. In fact, when we had the bars in Buckhead, one of my sentence alternatives, I banished people from Buckhead from 10 o'clock at night till 6 in the morning, unless they lived or worked there. One say, well, I live in Buckhead. I said, well, you're grounded for the next whatever. You can't behave and all sorts of disorderly conduct. We still have banishment in Georgia. I use it sparingly, but when we had the big problems with the bars and the drinking, that was something I had. This obviously is the other end of the spectrum, but I'd like to have this arrow back in the quiver, so to speak. It's a good one.
Thank you, Judge. If we need somebody banished, we'll send them to your court. That's fine. Chair, I'm sorry, I missed you. Okay. All righty. We have one other person to comment on the AARP issue, and that's Jerry Lee. Jerry, thank you for coming. We are running late, and you bear the brunt of that, unfortunately, but I think we understand the issue from the judge's perspective. Why don't you just tell us real quick what your situation is?
I'll be very brief. So good afternoon, Chairman Rice and members of the committee. I am Jerry Lee, and I am a Deputy State Coordinator for the AARP Driver Safety Program. That is not a paid position. I'm a volunteer. I've been volunteering with this program now for 9 years, and during that 9 years, I've personally taught 170 of these classes to over 3,200 participants. So, we're making a little dent out there. I represent a fellow bunch of volunteers. There's almost 200 of them out there also instructing and teaching this course. It is a 6-hour course. It's been around for decades. It's taught nationally, and what we do here in Georgia is just localize it. The core curriculum is geared for those people that are seniors, 50 and above, although we can certainly teach middle-aged people and young people as well. The core actual driver safety, the core principles are the same. It's just that we, because of our audience, not turn it on? Okay. Could you not hear me?
No, it's fine.
I thought you could hear me pretty well anyway. In the material that you have here, you can see that in Georgia last year for 2011, through the classroom course, we taught over 18,000 Georgians. We also have an online way they can take the course. So almost 21,000 Georgians took the course last year. We feel pretty good about this. Overall, we're about 6th in all the states out of the 50 states plus the Virgin Islands that teach this course. But truthfully, we're probably the best secret, unknown secret in terms of that return on investment that Judge Jackson was talking about. As you can see there, we're not trying to make any money. It's not all about the money. We're just charging a fee to cover the cost of materials and the certificates. So it's $12 for AARP members and $14 for everybody else. We even do some special promotions. For educators, we just finished the month of July and August, which we let them take it for $5. During the month of November, anybody that has served in the military can take it for free. Their dependents and their spouses, same thing. And we did that last year in 2011 as well. Prior to House Bill 269, which passed in 2011, you were all familiar with, what went into effect was that, you know, a lot of those traffic court judges were successfully referring senior drivers and others who had basically clean driving records to our courses. It's been my experience, my personal experience in teaching these people. You know, they don't even have to tell us that they were sent by the court. But oftentimes, and you were talking about attitude, I heard that this morning, these people are embarrassed at getting a ticket. They will admit, some of them, others we teach, you know, I never know. But they are embarrassed at getting the ticket. They're really grateful for being given that alternative by a judge. They generally are excellent students, blend right in with the rest of the group. And like I said, there's a lot of them that are probably in the class that have been sent that I wasn't even aware of. Now that was all prior to this year. Now with House Bill, you know, 269 being passed and becoming effective January 1, we've lost that group. Now we're going to be around teaching that course no matter what, you know, to seniors, whether judges send them or not. But it's been a great, in my experience, it's just been a great alternative solution. I'm not sure that you intended that to happen with the legislation last year, and if that is an unintended consequence, then it would be good. And I've included language in my testimony in the bottom. You can read. It's an easy fix. You can just let our course, which or any other courses that come under Code Section 33942, be an alternative as the sentencing option. Thank you for the ability to be able to testify here before you today.
I think you have a question. Chairman Powell.
Having heard the previous testimony about the abuse of discretion that may be occurring in some courts, and with this not being a state-approved course, how would you go about giving judges the discretion and the option to use this without running the risk of judges abusing that discretion by steering people to a particular county or a particular relative's court?
That is your issue. That's I hardly see. We have a purpose out there, and our purpose.
It probably would not hurt for you to help us solve that issue if you want that course to be utilized.
Yeah. Well, I certainly think having us as an alternative, as well as there's other courses that fall under that same code section, and they've been approved and been around in Georgia for a long time, and you know what you're getting with that. So I think, and that's what our suggestion is that you just add that or provision in there to let these people do that. I think that takes away. It's still, I don't know whether it solves that problem or the other discretion you have or not, but I'm not sure we would have any way of knowing how to do that.
I don't see any other questions, sir. I really appreciate you coming down here today and taking your time to do this, particularly for your volunteer efforts. Take care.
Thank you very much.
Thank you. Okay, Bob, I know you've been waiting back there patiently, and we are off schedule by only a long period of time. But Bob, you served as director of GOHS for a long time, and I know there's an issue close to your heart, and we want to hear what you have to say.
Well, thank you very much, Mr. Chairman and members of the committee. Yes, I've actually been working with the Motor Vehicles Committee, Representative Powell, since we first met, which I believe was 1990. And what this committee does, along with Judiciary, in conjunction with what goes on the road, to me has been important. In fact, I think combined, these are the most important committees because there's little else that everybody does than do something on the roadways. Whether you're driving, a pedestrian, a bicyclist, riding a bus, you're on those roadways. And the issues that this committee is facing with respect to either decriminalization, the driver's ed school, or the overall code review, I think are to be applauded. Because by your looking at them, then I think you're focusing attention on something that is dynamic over time. And I do have to say this when it comes to the state of Georgia, and the efforts that this committee has put forward over the past 2 decades I have been involved. if you're not the best in the country, you're second to none. And I say that because of the outcome. You look at the data with respect to the safety results that we've achieved, whether it's teen driving, impaired driving, excessive speed driving, we have done extremely well. And we have saved thousands of lives because of your efforts. And quite frankly, when you think about it, it does come down to being a public health question, because you're making it so that we are safer and therefore more healthy within this state. And the issues that you face with respect to the different areas, whether it's occupant protection, impaired driving, excessive speed, pedestrian bikes, commercial vehicle safety, engineering, licensing, DUI courts, teen driving, all of those I've been involved with intimately. But one of the things that I've observed over those years is the ability to do extremely well in each of them relies on two things more than anything else. One is data, and two is best practices. And as we all know, sometimes it's excruciatingly long to get to the right answer and convert it into legislation that then becomes a policy of this state. And so as you are looking at all of the entire code, because it's built on top of each other, every component of it, be very mindful of the fact that those components were put in there with that, data and best practices. So I don't use the word of unintended consequences because I think we're all pretty smart and can look through things. But whatever the consequence is, be aware of it, understanding what that consequence is and accepting it or not. That is obviously the things that you get to do in your position. But I suggest to you that there are so many things that are tied together. I mean, simply, for example, when we talk about the issue of decriminalization, how does that affect crime? Well, I could talk about all day something called data-driven approaches to crime and traffic safety and suggest to you that's a NHTSA Department of Justice program that would be very effective in solving two issues that most states face, namely a lot of traffic deaths and too much crime. But they're tied together. So each of these kind of interweave not only within the traffic safety arena but other arenas. And again, it gets back to the point because so many people drive, so many people are on the roads. It's something that we all do together. And I will close with this fact. There is little else in legislation that does more to try to affect behavior than the rules of the road. That's our job, really, when you think about it. Frankly, if we all drove perfectly, and I could ask any audience, raise your hand if you're a bad driver. Nobody will raise their hand. Okay, occasionally, okay. These are probably the good drivers. And that's the sad part about it, is that, we all think we're good drivers. We don't make the mistake. But last time I checked, we're still all human. And so all these things serve a purpose to change behavior. And again, I would just suggest that in any of these different areas, I'm more than happy to help, but I know you have a whole group of people that are more than happy to help. Understanding that data and best practices, I think, is what most of the folks have put forward over the years to end up with this result that we have today. And that is, as a state, we have done a great job over the past several decades because of your attention to data and best practices to create great policy.
Thank you, Bob. I appreciate that. Any questions for Bob? Bob, you're right. I mean, there's no question about that in terms of the data-driven best practices results, and you've been tutoring us in that for a long time, and we do appreciate that. Thank you. Alan just was lifted off his chair by the comments about the last 20 years in terms of the improvements we've made, and
I can't say that directly to him. I'm saying it to you, Mr. Chairman. But he's been part of the solution in a great way.
Thank you, Bob. We appreciate your testimony. All right. Ms. Cunningham, are you still here? I don't know if she's still here or not. Okay. And Ms. Hubbard, is there you are. Okay. I'm sorry, Ms. Hubbard, but you are the last person on the list here, but we're glad to entertain your thoughts.
Thank you. Thank you so much. It's an honor and privilege to be here and finally talk about something that I've been have taken a vested interest in for several years now. I just wanted to speak to a couple of what our presenters have said so far that I definitely agree with. Let me just say this. In the interest of the public, when coupled with other legislation that's not part of traffic, the quality of life of Georgians is being significantly affected. When you couple at-will employment as well as non-judicial foreclosures where a judge can still send a sheriff to your office or to your house when there's obvious title fraud. And then you couple that with, the minor traffic violations. Our money, our emotions, everything is being significantly affected and causing serious financial and emotional hardship on the residents of Georgia. And I'm not sure if you already know that one of the municipalities is also having a lawsuit regarding the way they've adjudicated used laser traffic devices when they were implementing traffic stops. So in the interest of the judicial economy, the decriminalizing would definitely be a benefit. I appreciate some of the comments by Judge Norton. He stated that, we were talking about jury trials. I'm not sure which jurisdictions those people were in, but in my experience, I requested a jury trial in the municipal court. It was bound over to the state court, demanded one there, and within a year I never got one. And some of the presenters have also said that those cases were dismissed prior to even getting to a jury trial. Mine was not. So I'm not sure, what's happening, in the courtroom where, we're being prevented or deterred from having an actual jury trial when demanded.
May interrupt you for a minute, Ms. Summer. This is an incredibly detailed document. I mean, you obviously have spent a lot of time in dealing with the court system, and I assume that you're coming to us with this knowledge based upon your personal experience of having been cited for an offense and attempting to work through the system to adjudicate it, right?
Absolutely. When it comes to the type of offenses we're talking about, those offenses that will never result in injury to any person or any property and things like that. That's not having your registration being late. It may be valid and you may not have it displayed, or it wasn't sent to you on time. The officer stopped you. We're still attached to criminal liability when that happens. You guys were talking about not having your driver's license on your person at the time when the officer stops you. I remember back in the 90s when it was a crime not to have your registration, it was a crime not to have your insurance. Those things are now tied into a system now, computer system. And I think that not having your license on you at the time, some people just forget. You're a soccer mom, you're a basketball mom, you have all these things to do. Sometimes you just forget your license, And if it's valid, it should just be a warning. But I think that the implications of someone not having their license when they're stopped, there's a lot of liars out here, where people can start lying about who they are. I understand that part. But if it's not a habitual thing, somebody, maybe within 12 months, 24 months, forgot their license 3 times. After 3 times, maybe there should be stiffer penalties. But every now and then you're going to forget your license. So, to have a criminal, be arrested at the traffic stop for not having a license, I think that goes above and beyond the abuse of power. I have a couple of examples of some things that happened at the traffic stop. I believe that there should be traffic stop reform. Police officers should be held accountable. There's legislation that states that when you get stopped for a traffic speeding ticket, the officer is supposed to notify you of your right to calibrate the weapon. What they're saying is that we're not allowed, we don't have to do that, we only have to do that in the court of law. I did speak with Jennifer Ammons of DDS back when that happened, and she said that's still a standing law, that they are supposed to notify you. That is still a standing code, but for some reason they're not being, I don't know who's training or whatever, but they're not being held accountable. The other thing is, when it comes to the actual infraction notice, other states do have a separate notice than the citation for misdemeanors or felonies or whatever. And I think that being forced to sign that at the traffic stop and being taken to jail if you don't sign a contract violates contract law. We have a right not to sign something. And I think with Georgia rules of civil procedure, when you're served your copy, that should be sufficient, especially with a minor traffic offense. I think, it's my opinion that even the courtroom procedures should be, with minor traffic violations, if we can handle some things by the mail, I think that would be sufficient. Judge, what was his name? Judge Jackson, he just recently spoke to you about the driver education program where they get their certificate. They don't have to appear in court. They can send it in by mail. If we have registration, we were late on, we got a warning or something like that, we took care of it, we should be able to send it in by mail as proof that we took care of that, and not get a bench warrant issued or high traffic fines. The other thing is the fine levels for infractions versus misdemeanors. If an infraction is over $200, that is creating a significant financial burden on Georgia residents, coupled with non-judicial foreclosures. We're fighting for our homes. We're fighting for our jobs. There's at-will employment without exceptions. Georgia doesn't allow exceptions. So we're fighting for all this. Now we can't drive to the store or take our kids to school or do anything like that without having to go to court. So if we know that a fine is going to be $200 or more, we're going to want to come to court because we want that dismissed. But a lot of times, drivers are counting on that officer not being there, and it's going to get dismissed anyway. So, we're wasting a lot of time forcing people to come to court for things that, are minor in nature. So the benefits of, the decriminalization is, there won't be any torts against the state. The example is that Stone Mountain already has $58 million lawsuit. When you couple all those things together, non-judicial foreclosures, at-will employment, now traffic offenses, or when people are moving here from other states that don't treat them as criminals for the same thing, you're like going backwards. It's like me moving to South Africa when they had apartheid and going back into slavery. So, if I'm coming here and being treated as a criminal for something that's not the same thing in another state, we don't have equal protection under the laws. And, our privileges and immunities are being very well being violated. I do agree with, Judge Gary Jackson. He talked about the collectability of the fines. I have no problem with you taxing my refund. I actually don't agree with my friends and family using their refund as income. It's a privilege to have a refund, but if you're counting on that to pay your rent or something like that, it's actually extra money that you should be investing or something like that. You should be able to pay your, pay your mortgage and all that kind of with your disposable income. So what not decriminalizing does, it taps into our disposable income that we already have. So if we're losing our jobs, or we're losing our homes, our disposable income is being taxed by having to pay these fines. If you can find an alternative to those, to collecting the fines, I'm in total agreement with that. I am in total agreement with DUIs staying criminal. Those type of offenses, I'm just not even worried about. I'm really worried about those things like, not having your driver's license on you, not having your registration and your insurance, and things like that. The other issue I would like to request that gets placed into legislation is the legal excuse. What's a lawful excuse? It's been hard for me to find out what a lawful excuse is that will exempt me from, exempt someone from coming to court. I haven't seen that in the Georgia legislation, so if that can be made public, that would help even in other types of offenses. So I just have some other examples, what other states are doing, what they're enjoying, and some other arguments, and just some examples of some of the violations that, I recommend you guys review. And that's it.
It's not a lot of work, Ms. Hubbard. It's
Well, my
certainly
rights are
more than I would
important.
have done. You got to run for office, going to be on this committee. Are there any questions for Ms. Hubbard? Summary, thank you for all the work that you've done, and we'll take your comments into consideration, some of your agreements and some of your changes that you recommend. Thanks so much for coming down today and waiting around all day to be sitting in that seat.
It's important to me.
It obviously
I'm
is.
tired.
It obviously is.
I want to just drive. I want to be able to mail in my thing.
Just drive and mail in the fee. All right.
And I have to come to court.
Well, we're not all about mailing it in, but we'd like to most of the time.
All right, thank you.
Okay. Well, it's 3:30 now, and we've completed. Is there anybody else that'd like to speak? Amen to that. And but thank you all for hanging in today. I know some had to leave a little bit early, but it's been good to have this conversation. What we're going to do is we're going to try and absorb some of this a little bit. And my plan would be, if it's okay with you guys, is to come together to review some of the information we've had today via conference call. And then we'll set another date for a physical meeting to come together once we've isolated the items that we want to focus on specifically. Okay? And if we can do that, that would be good. I'd like to have you think about prioritization of these issues and where we might go with it. Anything else for the good of the committee from the standpoint of this group? If not, the caucus has a conference call at 4 o'clock today, I think. So, is it today? It is today at 4 o'clock, I think. Yeah. Okay, thank you.